horrible rhino gets in, that's when the false flags are going to take place. So, no. They're not going to have Big Mike, or they're not going to have Gavin Newsom. They want Biden to lose the general election, but they want him to defeat Kennedy. Now, the question is, what could we do about it, and what should Trump do about it? Now, in terms of what Trump should do about it, Trump better get a very good legal team. Now, Giuliani, they're looking to take away his ability to practice law, I heard, in Washington, D.C. They already took him out in New York City. Now they want to mess around with him in Washington, D.C. He better get a good team of lawyers, because Roger Stone pointed out he has a very weak team. And he better fight very hard legally not to get out of that venue in Washington, D.C., because that's a kangaroo. That's a joke. He has to do everything he can. He should appeal to the Supreme Court. He should have everything he can do to highlight that there's no way he can get a fair shake in Washington, D.C. That's number. Now,
no, I totally agree with you. And the old saying of kangaroo courts in Australia comes from Australia's all railroads and kangaroos. They railroad you right into conviction. Thank you. Great points. Amazing, Robert. I totally agree with you. Bob in New York, you're on the air. Go ahead.
Hey, Alex. Love you, man.
Love you.
And I wanted to stay on your topic with Trump, and I feel that the moves that are being played out against him are really just kicking the can, the deep state kicking the can down the road. They're running out of moves, and they have to distract from all the other things that are coming out. They don't talk about the #1 movie in the country, a $15 million film that makes $100 million. They don't talk about what Tim Ballard and Jim Caviezel are talking about when they get interviewed. They're mentioning the organ harvesting, the blood, the 15 rapes, the marrow, the adrenochrome. They're talking about this stuff. It's being left on YouTube. Somehow it's not. It's being...
No, but you're right. Everywhere the truth's coming out, the deep state New World Order is burning down in front of our eyes.
Absolutely. And the only thing that they have to get at us is to go after the fearless leader, the one who, in my opinion, really just keeps his mouth tightly closed, doesn't talk about all this stuff because it's not time to get one person or this one or Wiener's laptop or Hunter Biden. The only time that it's going to come forward is in God's timing, and you see God's hand moving. You see the
no, we see God's hand working, and that's something I want to say. Despite how dark things are and how bad they are, we're seeing record awakening. The globalists, they're in trouble. That's why I'm saying they're going to counterstrike, and that's why this is so crazy.
Yeah, and there are a lot of things that he doesn't talk about that other people are. I mean, I'll say it. I'm Q adjacent, right? So you talk about Executive Order 13838, which talks about relieving people of their ill-gotten gains. You talk about who are the Joint Chiefs of Staff. If you look now, they're appointed in 2019. Now, if you were Joe Biden, wouldn't you get rid of Trump's Joint Chiefs of Staff? Of course, Milley was in there, but I think also Pence is a dark artist, and so Trump, in his brilliance, doesn't put him on stage to be taken down by Tucker Carlson in 2015 or 16 or 17. He puts him right next to him as vice president, and almost like a captive, almost like he's showing the world that we got you. And
I appreciate your call. I mean, look, a lot of what you're saying, I agree with. Some I don't. The fact that Trump knows everything works as this master super genius is not true. He thinks about freedom. He cares about the country, but it's not 3D chess. He brought in all sorts of folks that were bad because he didn't know. Once we warned him, he'd try to get rid of them. The whole Trump's got it all handled, everything's fine, everything's beautiful. It's not the case. It's that evil's not that powerful, and that if we all take action and speak up and don't submit and pray to God and do the right thing, we'll beat this. Let's talk to Mark in Utah. Mark, you're on the air. Go ahead.
Yes. I'm just going to bring up these two quick points. With Tom Hanks, it was bosom buddies, Alex. It was a TV show around 40 years ago, and he mostly played a woman throughout the show. Tom Hanks did that. That's where he really got his start, if I'm not mistaken, was with bosom buddies. Your crew could look that up. Now, the other point I just want to bring up, this is separate, because you keep saying things about JFK and the father, and then, okay. I believe JFK Jr., in my opinion, was killed I don't remember some form of assassination, because I don't remember ever hearing any plane found, any bodies found. JFK Jr., his wife, the baby, his sister-in-law. Okay, they were going towards, I think it's, I call it the compound in Massachusetts. Okay, and the plane in bad weather, I think, succumbed to the bad weather, and they died, supposedly. But I don't remember ever hearing they finding luggage, finding the bodies, or finding the plane. If you could add to
that's a very popular idea that he was murdered. I wouldn't put it past him. So yeah. What are you saying?
In my opinion, if they didn't find anything, I believe 99% he was probably assassinated.
Sure. So what does that mean? How does that affect today?
No. I'm just bringing that out. Because you've been bringing up lately the Kennedys. So I'm just throwing that out. He was going to run for president,
Sure.
He had a lot of support. Yeah, excuse me?
No, I agree with you. I think they probably did murder him.
Yeah, that's what I believe. Okay, can I go to my real point, please? Okay. Joseph Smith of Jesus Christ of Latter-day Saints, whether you know this or not, he ran for presidency in roughly 1840. Okay, and he was basically assassinated, in my opinion, and he was tried in absentia by the Missouri and the governor of Missouri. And listen to this for 1 minute. You could have your crew. I wish you would have your crew look it up, because that's why I bring these points up to you, Alex. Okay, what I'm bringing up to you is the New Yorker magazine in 2019, the March edition, will say that Joseph Smith of Jesus Christ of Latter-day Saints, the prophet, ran for the presidency of the United States of America. And then you read the article, and it almost matches exactly what's going on with Trump, because they tried him in an extensia, which means that he wasn't in the courtroom doing whatever you would do.
Yeah, sure. It's basically a default. It's the same thing to me. Very interesting. Thank you so much, sir. All right, we're going to go to break. Vic, Savix, Carlos, Daryl, Joey, we're taking your calls. The order they are received. I'll host a little bit in the next hour with some other breaking news, and then hand the baton to our special guest. Then, at 3 p.m. Central, about an hour and 20 minutes, Owen Schroyer with the War Room takes over. Infowars.com/show. Please link to his show and promote it. He's covering critical information. With all the craziness in the world, the collapsing borders, the war with Russia, the insanity, the currency devaluations, the economy going crazy, you are crazy, in my view, if you don't get high-quality storable food and water filtration and self-defense. Now, we're not selling guns and ammo. That's for you to go out and get for yourself and learn how to use if you haven't. And I'm preaching the choir on that. But a lot of people got plenty of guns, but they don't have enough storable food or water filtration. This is something you need now, and we've got it in the food department and in the high-quality water filtration department. The highest quality food, the best water filtration at the lowest prices you're going to find and still get quality. InfoWarsStore.com is running a special right now for 10% off on all storable food and on water and air filtration. Ladies and gentlemen, you cannot beat this deal. Our prices are already the lowest. At 10% off, it's an insane deal for a limited time. Go to InfoWarsStore.com and get prepared while you still can. I want to thank all of you over the years who have supported InfoWars financially and with word of mouth and prayer. All the success that we've had together against the globalists, the fact that we're not caught flat-footed during their major takeover, is because of you. Humanity has a real fighting chance. I just want to thank you all for buying products at InfoWarsStore.com, like books and films and supplements and water filtration, air filtration, and so much more. But for those of you that want to actually give us a straight donation, so we get almost 100% of the money to fund our operation during this critical time, go to InfoWarsStore.com, and right at the top, you'll see a link to make a straight donation. A one-time donation of $5, $10, $50, or a recurring donation you can cancel anytime. I want to thank all of you that have donated. I want to encourage those of you out there that want to support freedom to take action now and be part of the global awakening, the new renaissance that's countering the Great Reset, by going to InfoWarsStore.com and clicking on the donate button and giving today. Thank you so much for your support. Please take action.
Iodine is naturally acquired through the soil, which is at the foundation of our entire food supply. Modern farming techniques have stripped the soil of this essential trace element, which has caused an iodine deficiency in about half the population. And there are two things we need to do about it. We need to practice more
And what you want to do is you want to get some exceptions to the policies in the cuckoo nest. Well, why don't you go to administration and say, I want to check out? And then when you check out, you got direct access. You don't have to go from permission to the cuckoo's nest every time you want to do something. So there's a higher methodology of deciding where you're going to go in your life. Then when you find out that the asset account is an account of great value, and you're going to have the opportunity to go out and help your brothers and sisters by using your account and your blessings, then you got to go to circle number 3 and say, how am I going to be able to protect this operation so it doesn't look like I'm a terrorist against the cuckoo's nest by all of their public officials that don't yet understand who I am, and what I'm doing, and that I've been given permission by higher-ups in the cuckoo nest to do what I'm doing. Otherwise, they're going to snatch you off the street and put you back in the institution. Yes.
So what constitutes like terrorism? Because I think there's kind of a fine line.
Terrorism is use of your commercial assets to oppose the policies and the politics of the democracy.
They got a ton of policies. I mean,
they do. And who does those ton of policies apply to?
They apply
inmates in the cuckoo's nest.
That's right. But if you're, I think you just have to be fine line there and operate privately. Completely.
Brandon, is there a fine line between being alien and being citizen? Or do you think that's kind of like black and white? You either is or you ain't. If you're the citizen, you're in the cuckoo's nest. If you're the alien, you're not a member. Where's that fine line?
Okay. Question.
I need batteries.
Question. What kind of questions would they ask in a competency meeting with an agent?
Sir, do you know how to access your asset account in such a way that it's not going to disturb Chase Manhattan when you come in? Or do you know how to go out and buy a hamburger at McDonald's without getting yourself into trouble? Remember the story we told yesterday about the traffic ticket guy that went down to cash his straw man's check? Do you think he was demonstrating competency? He failed the test, didn't he? So the judge could have said, well, give me your birth certificate and your driver's license. And oh, by the way, you're not going to go down and cash your straw man's check this week, are you? And the guy is going to go, wait a minute, how am I going to buy food and gasoline at the gas station? I need to cash that check. It's the only way I can purchase things. Beep, you lose, you're incompetent. Now how do you plea to the charges? See, haven't we already implied that if you're using Federal Reserve notes, you're passing limited liability? That's not a remedy. Does that mean that you can't go to the gas station and use a Federal Reserve note? It's not what you do, it's the way you do it. Last night, did we not talk about filing a 1040 in order to do what with regard to Federal Reserve notes? To really discharge the public liability so that there was no increased public debt. Now, just because your straw man used a Federal Reserve note, is he going to hell or purgatory? Or what does he do after he uses the Federal Reserve note? Or what declaration did he make before he used it? Remember, we talked about the fact that Gordon had a limited endorsement on the back of his checks. If our friend would have taken his check into the bank from his straw man that he had gained from the wages and put the limited endorsement on the back of the check, Do you think that the judge, if he knew that, would have called him in? Chances are no, because the limited endorsement does what by notice? Gordon is not receiving the benefit of limited liability through the use of Federal Reserve notes. So therefore, there is no public benefit there. But on the other hand, would Gordon set off that benefit in the background notwithstanding and discharge the public liability caused by the trace use of that? Gordon hasn't gone there yet that I know of. You see what I'm saying? This is all about whether or not you're creating this pig pen surrounding to you as you go through life, this cloud that hangs over your straw man's head, or whether you're fixing things as you go through life. This weekend, don't they have a movie out from Disney? Wreck-It Ralph. What? That's every one of you guys are Wreck-It Ralph. Every place you go in the game of life, you're screwing it up. But one day, Wreck-It Ralph woke up. Haven't seen the movie yet, but I've seen the previews. I know where it's going. Wreck-It Ralph woke up, and Wreck-It Ralph says, my whole life, I've been going around destroying things. And I've decided I don't want to do that anymore. And he goes to the equivalent of the Alcoholics Anonymous meeting where we've got all of these bad guys. I don't want to be bad. I don't want to be the straw man. And at the meeting, the one guy, the monster, is going, well, just because they call you bad guy doesn't mean that you're really bad guy. And I did, Nancy. And so Wreck-It Ralph is now, by trying to be good, what is he wrecking? The whole society, because his goal is to be straw man wrecker. And he's jumped his game. And he's going to be the nice guy in everybody else's game. And it's thrown the whole game world into chaos. That's what happens when you turn around and don't be Wreck-It Ralph no more. It becomes chaos. And so what the hell is Disney trying to tell you? Stop being the straw man. Go out and do good. That's what our problem is.
I was born outside the United States, and I lost my birth certificate, and I have a U.S. passport for my parents. How do I don't think I have a social security card number. Do I need to apply for one? Should I apply for one? How do I?
You've got a U.S. passport. You were born outside the United States. Did you come into the country through some entry document? Naturalization. Because if you did, your birth certificate, a state account got moved to the United States through the naturalization documents. If you did not have naturalization documents, you're not a U.S. citizen resident. You may be here legally or illegally, but the account on your asset account is held with the birth country until you move it by way of applying for entry documents formally through the country that you're in. In order to get a social number, you're going to have to attach it back to the birth certificate or the naturalization entry documents, because the Social Security number is going to attach to that asset account, which attaches to the birth, or the transfer of the birth account by way of the naturalization documents. To whatever extent the paperwork following where you've physically gone has not kept up with you, you're going to have to go back and make sure the paperwork corrects whatever it is so that you've got authority to apply for the Social Security number and formally be attached to that account.
So I should apply for
Go back to the naturalization or the entry documents, whatever got you into the United States from your former birth country. And that's a starting place. And if you've lost those documents...
I didn't really fill out anything. I just showed my passport and...
Well, if you have a passport, it had to attach to something in that account somewhere.
So maybe I filled it out in the country before I came to the United States?
You might have applied for the U.S. passport overseas through a U.S. office, yes.
So that's the actual...
That would be the records then of the transfer of your asset account to where you are. No matter where you are in the world, every one of the approved countries in the world are going here. For instance, in Mexico, they didn't have recorded birth certificates and a lot of that crap in many of the rural outlying areas until the 1970s and 80s. And they already knew that Mexico was going to be the manufacturing center for the United States. And so in order to get prepared that Mexico was going to get our jobs and start manufacturing, they had to start building up the understructure for the economy in Mexico. The roads, the water, the sewer, the electric, whatever it was. And in order to pay for that, they needed to have some assets to do that. So in the 1970s and 80s, they made a concerted effort in Mexico to get people to apply and file birth certificates if they had never done so, even on people that were born many years back, so that they could generate the accounts, so that they could borrow the money from IMF, World Bank, and everybody else to generate all the facilities that were going to be put in place so that it would support the corporations that came down there with the manufacturing jobs. We're just saying that the third world is being lifted in to the modern commercial system, if you will, by registering people, because it's that registration which has been the underpinning of the so-called economy money system. And they're very careful to be doing that, so that if a nation doesn't have any people registered, they have no basis upon which now to create the funds to build up their economy, to go into production, consumerism, and everything else.
So when I applied for the U.S. passport, that's when I created
when they offered it to you or got it to you, most likely there's accounts there that have moved your asset account into the United States.
So now my record is up to date.
I would presume it is, yes. Have you got a Social Security number?
I never applied for one. I never went to.
Well, apply for one, and if it goes through, then you know that they got all the
I needed a birth certificate. I didn't have it.
Yeah.
So I need to get my birth certificate.
The foreign birth certificate is not what you need in the United States to get your social number. What you need is the documentation that brought you into the country. And that should be separate and apart from the passport, or it should have been in place prior to issuing you the passport. But it depends on what kind of passport you've got. You're not a citizen of maybe a national.
This is my passport. I think it's a regular passport, just like anyone else.
Did your parents bring you here at what age?
They never brought me here.
So you brought yourself?
Yes.
Okay. You don't believe that you applied for Social Security?
No.
Okay. I'm going to say that. How long ago did this happen?
I came in here?
Yeah.
3 years ago.
Okay. I'm going to say that's probably not exactly what you think happened, but okay. So Jack said, go to the Social Security office and apply for whatever to find out that you're not.
Or see what Social Security says. You know, tell them you're.
They asked for 2 documents besides your another passport, and they want a birth certificate.
So this time we all have a message for Brandon. So.
This is love, Brandon. So, are you sure you want a Social Security number?
I'm sorry?
Are you sure you want a Social Security number?
No, I'm not sure. But I want to know that I want to access the asset account.
So the presumption is that without a number, you don't have access.
Yes.
Okay. Are you sure?
No.
Okay. So, what do you know about Social Security?
It's a benefit.
Do you want a benefit?
No.
Okay. So what do you need to do? If you want to access the asset account, but you don't want the benefits and privileges of Social Security. Is it the Social Security contract that created your estate?
No.
No. We talked about this yesterday because I just gave you an example of how my son would access his asset.
Non-citizen national?
Well, that's his status. I don't know if that's your status.
So what should I do, or how do I acquire the asset accounts?
Who's the alien property custodian?
Secretary of State or Treasury?
Treasury. Okay, so if the Secretary of Treasury is the alien property custodian, i.e. trustee for property and assets of aliens, who do you need to communicate with?
The head guy of the Treasury.
Okay, and what do you need to communicate to them?
That I would like to be able to access my prepaid account.
Are you going to ask pretty please?
Give them a notice.
Ah, what's the substance of your notice?
A UCC or some sort of file.
Is a UCC substance for anything? Anyone?
No.
No? It's just a notice.
So my substance is the right to access the prepaid account.
What's that?
My right.
Okay, so you got a right. So how are you accessing it? You already have the right. You said you were sending a notice. What's the substance of the notice?
I don't know. I have a right to the account, and I have the form, and I'm giving them notice that I would like to access the account, or will be using the account.
Okay. How?
I heard someone say security agreement.
How is the Secretary of Treasury to know when an obligation comes in? How is he going to know what asset account to attribute the obligation to?
The Social Security number?
You don't have one. So, what evidences the existence of that account?
Birth certificate.
And what authenticates your right to access whatever that
A
is?
unique identifier? A signature.
Mm-hmm. But if it's in the hands of the United States instead of the country of birth, your birth certificate is the evidence of the account. There's no Social Security number attached to it. There may be no equivalent number to a Social Security number in the country of birth. It's just the BC account. But if you came into this country appropriately and they authorized that, there's got to be a U.S. entry document that describes where your birth took place, and it's that entry document which overlays the birth certificate in the country of birth. The entry document is what the U.S. sees as the evidence of your account. If you want to authorize the attachment of a Social Security number to that account, you can authorize that to happen. What Brandon is saying is if you don't choose to do that, you don't have to authorize the attachment of the Social Security contract or relationship to that account. It's up to you.
So again, I was asking you what was the substance of your notice. How is the Secretary of Treasury to know, for one, you're the guy? How are they going to know that you're the guy who has the authority to access the asset in the account? And how are they to know when an obligation comes in, how to attribute it to that account?
Affidavit of Obligation Commercial Lien. This is a verified plain statement of fact. Maxims. 1. A maxim is so called because its dignity is chiefest, and its authority most certain, and because universally approved of all. 2. All men and women know that the foundation of law and commerce exists in the telling of the truth, the whole truth, and nothing but the truth. 3. Truth as a valid statement of reality is sovereign in commerce. 4. An unrebutted affidavit stands as truth in commerce. 5. An unrebutted affidavit is acted upon as the judgment in commerce. 6. Guaranteed, all men shall have a remedy by the due course of law. If a remedy does not exist, or if the existing remedy has been subverted, then one may create a remedy for themselves and endow it with credibility by expressing it in their affidavit. Ignorance of the law might be an excuse, but it is not a valid reason for the commission of a crime when the law is easily and readily available to anyone making a reasonable effort to study the law. 7. All corporate government is based upon commercial affidavits, commercial contracts, commercial liens, and commercial distresses. Hence, governments cannot exercise the power to expunge commercial processes. Notice to agent is notice to principal. Notice to principal is notice to agent. 8. The legitimate political power of a corporate entity is absolutely dependent upon its possession of commercial bonds against public hazard, because no bond means no responsibility, means no power of official signature, means no real corporate political power, means no privilege to operate statutes as the corporate vehicle. 9. The corporate legal power is secondary to commercial guarantors. Case law is not a responsible substitute for a bond. 10. Municipal corporations, which include cities, counties, states, and national governments, have no commercial reality without bonding of the entity, its vehicle, statutes, and its effects, the execution of its rulings. 11. Except for a jury, it is also a fatal offense for any person, even a judge, to impair or to expunge, without a counter affidavit, any affidavit or any commercial process based upon an affidavit. 12. Judicial non-jury commercial judgments and orders originate from a limited liability entity called a municipal corporation, hence must be reinforced by a commercial affidavit and a commercial liability bond. 13. Governments cannot make unbonded rulings or statutes which control commerce, free enterprise citizens, or sole proprietorships without suspending commerce by a general declaration of martial law. 14. It is tax fraud to use courts to settle a dispute/controversy which could be settled peacefully outside of or without the court. 15. An official, officer of the court, policeman, etc., must demonstrate that he or she is individually bonded in order to use a summary process. 16. An official who impairs, debauches, voids or abridges an obligation of contract or the effect of a commercial lien without proper cause, becomes a lien debtor and his/her property becomes forfeited as the pledge to secure the lien. Pound breach, breach of impoundment, and rescue is a felony. 17. It is against the law for a judge to summarily remove, dismiss, dissolve or diminish a commercial lien. Only the lien claimant or a jury can dissolve a commercial lien. 18. He who is silent appears to consent. 19. Consent makes the law. A contract is a law between the parties, which can acquire force only by consent. 20. Consent makes the law. The terms of a contract, lawful in its purpose, constitute the law as between the parties. 21. To him consenting no injury is done. 22. He who consents cannot receive an injury. 23. The agreement of the parties makes the law of the contract. 24. The contract makes the law. 25. Agreements give the law to the contract. 26. The agreement of the parties overcomes or prevails against the law. 27. It is immaterial whether a man gives his assent by words or by acts and deeds. 28. Ignorance of facts excuses, ignorance of law does not excuse. 29. In law, none is credited unless he is sworn. All facts must, when established by witnesses, be under oath or affirmation. 30. A presumption will stand good until the contrary is proved. 31. All things are presumed to be lawfully done and duly performed until the contrary is proved. 32. Notice to agent is notice to principal. Notice to principal is notice to agent. Public hazard bonding of corporate agents. All officials are required by federal, state, and municipal law to provide the name, address and telephone number of their public hazard and malpractice bonding company and the policy number of the bond and, if required, a copy of the policy describing the bonding coverage of their specific job performance. Failure to provide this information constitutes corporate and limited liability insurance fraud, 15 U.S.C., and is prima facie evidence and grounds to impose a lien upon the official personally to secure their public oath and service of office.
All right. Hopefully you guys can hear me. Hopefully I'm coming in loud and clear. Somebody give me a thumbs up. Let me know in the chat that I am coming in loud and clear, or raise your hand, give me a thumbs up, something. Let me know that the audio is working properly. So much to do, so little time. Today's date is July 18, 2023. According with the Gregorian calendar, it's approximately 3:13 p.m. Eastern Standard Time. Going to be going over a lot of things. Actually, for those of you that was in yesterday's class, we had I ain't going to say a snafu. I'm just going to simply say what it was. We got into a certain level of conversation, and I guess powers that be didn't like the conversation, so thus we had to reconvene in a different venue. But nonetheless, here on WTDTA Radio, Spellbound Media and Entertainment, this is considered to be compliance officer training, and it's designed to train civil law notaries in the ability to operate properly through a syntactical trust infrastructure. In this particular layout and or class, we do not profess to give legal advice. Each and everything that you're going to be listening to, participating in, is for educational purposes only. If you hear anything within this context that motivates you to take some sort of action, and it requires you to interact with what we call the public tribunal system, we ask you seek those professionals that are supposedly licensed and bonded in that regard, supposedly and allegedly, to provide those services, because here on WTDTA Radio, Spellbound Media and Entertainment, and all affiliate entities such as Apex Capital only profess to give information only, for educational purposes only. So with that being said, now the disclaimers out of the way, let's proceed. K1 disbursements, M3 conveyances. There's summertime in the air. Some of you guys are in the middle of your process. Some of you guys at the end of the day will receive your case syllabus, which is going to revolutionize the way you access and leverage your K1 M3 asset platform. This is not just a nice little book or ebook that you're going to receive. This is an actual living, breathing, monetizable document. It's a fungible token. It's like cryptocurrency. Let me just say it like that. This, what you're going to be receiving in this, with your case syllabus, is technically your own version of your own cryptocurrency. And if you listen long enough, you definitely will learn how to utilize it. Now, because we're going to be touching into the higher space of syntactical trust training, I made it clear for most that was in the class yesterday that I want you to participate from here on out in the class with the following. Please have some sort of device, laptop, tablet, whatever, that actually has access to ChatGPT. You're going to thank me later, because having that helps me help you help us. Certain questions are going to be over your head. Some going to be right where you think you need to be. And then there's a certain level of synergy and energy that I'm looking for in the responses. So the more interactive you are, the better the algorithm is, the better the responses are recorded, and then you're going to see some magic when you move forward to implement your M3 asset. Now, let's start with the affidavit of obligation. That affidavit of obligation that you heard a few minutes ago is the legal maxims that govern arbitration. There are a couple of you guys that are actually going through presently the civil law notary training. And I am literally trying to say without it being too cumbersome, the importance of being a notary is 99.99999% of your ability to move fluently. I know most of you who became notaries, up until you met me and heard this information, you probably never moved that way. And that's okay. But what you realize is that when you start moving under that umbrella, things in this sector seem to move a whole lot different than what you were used to. And again, there is a reason why I stay in the side of the ledger where I have the most protection. Somewhere I've read a superior man or woman stays in his or her own domain. So I will consider that being in this private domain is where all of the protections lie. Now, you may want to take certain risk out in the public, and by all means, you're equipped, insured, and bonded to do so. Well, at least I hope so. Like, how many of you guys are actually bonded and insured to operate in commerce? Let's start there. Oh, you didn't know you had to be bonded and insured to operate in commerce? Ain't it ironic that everybody else that you deal with that harass you about commerce, they're all bonded and insured, and they're usually harassing you, and you're not bonded and insured. Who doesn't see the irony in that? Who doesn't understand how that is even allowed? Better yet, who has a question about that? And again, please, if you have questions and I give you an opportunity to ask questions, ask those questions. Press 9-4 on your keypad. A hand will raise that'll signal to me that you have a question. I'll bring you on and I'll give you an opportunity to answer. But who doesn't, do you see the irony in this? Like, everyone who makes a demand for payment publicly, in order for them to ask for payment, they have to first be bonded and insured. So what does that imply about you, the person who they're making the demand from? Doesn't that mean you're supposed to be bonded and insured? And Mr. Bay, if I was bonded and insured, would I still have to give them fiat? Or couldn't I let them file a claim on my insurance? These are great questions. But again, I don't see nobody raising no hand, they ain't pressing no 9-4. So I'm just really doing either a really good job or folks are just, it's too early for them to ask questions. They don't want to say the wrong things. No such thing as asking the wrong thing or saying the wrong thing. I'm trying to take you somewhere, but I can't take you kicking and screaming. You got to want to go willingly. So let's start with who knows what an M3 asset is. I started class yesterday the exact same way. So we're going to pick up where we left off. Who knows what an M3 asset is? Is there anyone in the class that know what an M3 asset is? Press 9-4 on your keypad. All right. I'm going to call you by your last digits of your phone number. Last digits are going to be 2239. 2239. What is an M3 asset?
That's my question to you.
Oh, you're asking me the question. Hold on for a second, then. Just bear with me. Let's see if I can find someone who can answer that. Miss Flemings, can you hear me?
Yes, I can hear you. Greetings.
All right. Greetings. How are you?
I'm good, thank you. How are you?
Oh man, it's exciting times to be alive. I'm ecstatic. Can you tell us what an M3 asset is?
An M3 asset contains M2, M1, and M0 assets.
Okay. And for those that have never heard, for those that have never heard what an M2, an M1, and for that matter, an M0, what is an example like an M2 asset?
Would be a check.
Okay. What is like an example of an M1?
$20 bill.
Gotcha. So an M3 asset is like a time deposit, but it's also made up of checks and also $20 bills.
Correct.
That makes sense. Beautiful. All right. And these are the essentials. See, you have to know the type of money you're dealing with to know exactly how to convey within the constructs of the type. When we group money in just one category, what happens is we're realizing there are policies that govern different types of asset classes. Now, they say the devil is in the detail. So the most dangerous thing that you and I can ever deal with in commerce, which we'll call an M1 for conversation purposes, that's the $20 bill. That's the most dangerous one. And they call that money. Then if you're dealing with a negotiable instrument like a check, they'll call that near money. And then when you're dealing with a M3 asset like a time deposit, that's called near money. So listen to how it sounds. The most dangerous thing they call money, and the least dangerous thing they call near money. So what does that imply about money if the definition in the general population is that the most dangerous asset you can actually have on your person is called money? What does that imply? Let's not forget that everybody in the public who is charging you, asking you, demanding you, they're all what? Bonded and insured. So how is it that you have the most dangerous asset class in your purse and you're not walking around with some sort of bond and insurance to handle it? Makes you think, doesn't it? Makes you wonder. Got Brother Mark on here. Let's see if he's got any. Brother Mark, you got a question for me, big bro?
Oh, yes, I do. First question is the security bond. Is that just regular insurance that you have on yourself, or is it a different type of insurance?
Okay. When you're talking about bonds and insurance, this could be just like how we're talking the money supply. So I'm going to say that an indemnity bond or indemnity insurance is like the broad, big umbrella. And then when you have a money transmittal bond, that's just like a variation, a very specific. It's a specialized bond. So you have specialty bonds and you have general bonds. So I'm going to say for commerce, for all intents purposes, you need to have an ability to be indemnified in case stuff go left when you contract. Now you can cater that security agreement and or bond very specifically or very broad. Just like they have different types of insurance. You know, they got house insurance, homeowners insurance, car insurance, fire insurance, death and dismemberment insurance, annuity insurance, life insurance, term life, whole life. List goes on and on.
Okay.
So it would be to your advantage that if we're talking about handling the most dangerous money classification on the planet, then you need to have a type of insurance that allows you, if you come in contact with it, that you're not going to be liable for it.
Okay. I understand some of it. So is this something that we put together individually, or is there's a place that we can go and get it?
Okay. It sounds like you kind of got a little far from the mic, so I heard this is for an individual, and I couldn't hear the rest of what you were saying.
Is this something that we create ourselves, or is this something you go to an institute, or that's that part?
Okay. In most instances, you would want, as a notary, let me be clear. If you observe in commerce that any party in commerce is not bonded and insured, it's your job to point it out. Now, let's go back to the legal maxims, and then you'll be able to answer the question. When it comes to making the request for a public official to present to you their public hazard malpractice bond, they're as like, I'm gonna show this to you in real time. So let me just just bear with me while I bring this up, while I explain this. Should have a here we go. All right, we're gonna go to the admiralty claim. Here we go, right here. This is the public hazard bond, and I'm gonna go over this verbatim so I can share the screen. So just bear with me. I'm gonna share the screen, and we're gonna go.
I have a question.
Sure.
The public hazard bond can be written through our implied trust, right?
It can. Yes, it can.
Okay.
So what you are supposed to do when someone rolls up on you under the appellation that they are some sort of public official, all officials are required by federal, state, municipal law to provide the name, address, and telephone number of their public hazard and malpractice bonding company and the policy number of the bond, and if required, a copy of the policy describing the bonding coverage of their specific job performance. They're in your face telling you what you need to do. You need to check their credentials. Now, failure to provide this information constitutes corporate and limited liability insurance fraud under Title United States Code, and it becomes prima facie evidence and grounds for you to impose a lien on them upon their official personally to secure their public oath and service of office. So in other words, since you couldn't show me no insurance, I got to put a bond on you because you can't be going around saying stuff in the public unless you're bonded and insured to say so. So you can't go around just saying stuff and not be bonded and insured. This is why I say the stuff that I say, because I'm bonded and insured. I can say this type of stuff. Someone said, well, Mr. Bay, what gives you the ability and right? Simple. I don't, like my grandbaby said, you're not the boss of me. I'm the boss. I know what I want to do and how I want to do it. So you have the opportunity to totally control the narrative when it comes to M3 assets by requiring whoever is an official to show you their bond. Their failure to do so puts you in the catbird seat. Now, the type of bond that you should create, in my opinion, probably falls within something that I just read. I gave you a title, which is what? Title 15 United States Code. Well, sort of, kind of, maybe whatever I get, if it doesn't cover Title 15 United States Code, maybe it should. I'm not giving legal advice. I'm going to say that my indemnity bond, I couldn't think of everything, but I think I put enough in it to kind of cover enough where I can speak confidently about M3 assets. That's why I use the term, what you may call money, I may not.
Okay. Thank you.
All righty. All right. Who has any questions pertaining to what we're talking about in the interim?
I have one more question.
Sure.
When you was just describing the different M1s, M2s, when you got to M3, you said $20. A check.
M3 is a time deposit, so I help you. M3 is a CD, like a CD or an insurance policy. M2 is like a checking or savings account, and a $20 bill is an M1. Okay, keep going.
All right, that was it.
Okay. Any other questions? Okay, so if we don't have any other questions, what I want you to do is listen. Because if you listen long enough, probably going to learn something. Bear with me.
Unraveling Trust Law, Understanding Property Rights and Legal Obligations. Introduction. In the intricate world of legal disputes and property ownership, it is crucial to comprehend the nuances of trust law. This article explores a thought-provoking transcript that delves into the realm of trust law, discussing the distinctions between an executor and a trustee, the importance of clean hands in equity, and the impact of full disclosure in contractual agreements. By shedding light on these topics, we aim to provide a comprehensive understanding of trust law and its implications for property rights, trusts, and the public domain. The transcript initiates with a profound statement: everything dealing in the public is trust law. This highlights the prominence of trust law when engaging with legal proceedings and courts. Particularly, when individuals encounter courts, they are likely dealing with a constructive trust, which operates solely in equity. Understanding the nature of trust law becomes crucial in comprehending legal situations accurately. Executor and trustee, roles and responsibilities. To navigate the intricacies of trust law, it is essential to differentiate between the roles of an executor and a trustee. While both may bear similarities, significant distinctions exist in their duties and obligations. Executor. An executor is responsible for fulfilling temporary duties related to the collection, conversion into money, and disbursement of assets. Their role typically involves legal proceedings such as probate or law courts. Trustee. On the other hand, a trustee assumes more permanent functions of administration and management. Trustees have fiduciary obligations and responsibilities towards the property under the trust's purview. Their actions are guided by equity and trust law principles. Equity and clean hands. One critical aspect of trust law is the concept of equity and the requirement of clean hands. Equity emphasizes fairness and justice, ensuring that parties approach legal proceedings with integrity and good faith. A crucial principle to bear in mind is that equity only comes into play when individuals demonstrate clean hands, acting in good faith and complying with their fiduciary obligations. Full disclosure and contractual agreements. The transcript raises the significance of full disclosure in contractual agreements. It highlights situations where individuals may unknowingly sign documents that have legal implications, such as negotiable instruments or promissory notes. Understanding the nature of these instruments and their impact on property rights is essential. Some key considerations include gifted property. When property is transferred into a trust, consideration is not always required. If property is gifted, no consideration is necessary, making it crucial to differentiate between gifted property and those involving consideration. Reading contracts. Individuals should diligently read and comprehend the terms and conditions of contracts before signing. Failure to understand the implications of a contract does not absolve one of its legal consequences. Studying trust law, empowering yourself. To effectively navigate trust law and property disputes, individuals are encouraged to undertake a comprehensive study of trust law. By immersing oneself in trust-related concepts, individuals can enhance their understanding of legal frameworks and strengthen their positions. Key areas of study include trust law fundamentals, gaining a solid foundation in trust law principles, such as the nature of trusts, trustee obligations, and beneficiary rights. Mortgages and trusts, exploring the intersection of trust law and mortgages, understanding how properties in foreclosure are often placed within a trust structure. Fraud and closing table practices, recognizing potential instances of fraud, such as fraud in the factum, which occurs when individuals sign documents without full disclosure or awareness of their true nature. Constitutional rights and trust law. The conversation delves into the relationship between constitutional rights and trust law. It clarifies that trust law, in and of itself, does not violate constitutional rights. Constitutional protections primarily pertain to private law, property law, tort law, and certain aspects of public law. However, individuals must consider their status and rights as U.S. citizens, as they may not always fall within the realm of constitutional protections. Continuous learning and seeking knowledge. Finally, the transcript underscores the importance of continuous learning and seeking knowledge in the field of law. It emphasizes that even legal professionals spend years studying and honing their expertise. Engaging in regular study, understanding legal nuances, and staying informed about developments in trust law are vital steps towards building a strong legal foundation. Conclusion. Understanding trust law and its implications for property rights is crucial in navigating legal challenges successfully. This transcript sheds light on various aspects of trust law, including the roles of executors and trustees, the significance of equity and clean hands, and the importance of full disclosure in contractual agreements. By delving into the depths of trust law and studying its intricacies, individuals can better protect their property rights and assert their legal claims with confidence. 1 hour 19 minutes and 52 seconds to 1 hour 31 minutes and 34 seconds. Reporting color of law abuse, empowering individuals to seek justice. Introduction. In today's discussion, we shed light on the topic of color of law abuse and the significance of reporting such misconduct to the appropriate authorities. Our conversation highlights the need to go beyond reporting crimes to the very individuals perpetrating them and instead seek justice outside of the agencies involved. By understanding the concept of color of law and familiarizing ourselves with the statutes and procedures for reporting, we can take proactive steps towards holding accountable those who abuse their authority. Understanding color of law abuse. The term color of law refers to situations where government officials, including law enforcement officers, judges, prosecutors, and security guards, misuse the authority bestowed upon them by local, state, or federal government entities. Color of law abuse occurs when individuals willfully deprive or conspire to deprive someone of their rights protected by the Constitution or U.S. law. This includes acts committed both within and beyond the limits of their lawful authority. The FBI's role in investigating color of law abuse. The FBI plays a crucial role in investigating color of law abuse cases. Acting as the lead agency for such investigations, the FBI recognizes the importance of preventing the abuse of authority by government officials and ensuring justice in our society. In fact, a significant percentage of the FBI's civil rights case load involves color of law issues. Types of color of law abuse. Color of law abuse cases typically fall into 5 broad categories. Forced sexual assault, any sexual assault committed by a government official while asserting their official status is a violation of the victim's rights. False arrest and fabrication of evidence, falsely arresting individuals or fabricating evidence to support false charges infringes upon an individual's rights to due process and protection against unreasonable seizures. Deprivation of property, unlawfully obtaining or maintaining a person's property, misapplying official authority, or engaging in illegal compensation violates an individual's property rights. Excessive force, the use of excessive force during arrests, maintaining order, or defending life can infringe upon an individual's rights. While law enforcement officers are permitted to use reasonable force, any willful, unreasonable, or excessive force violates the color of law statute. Failure to keep from harm, government officials have a duty to protect individuals from harm. If an official willfully fails to fulfill this duty and an individual suffers harm as a result, it constitutes a violation of the color of law statute. Filing a color of law complaint. To address color of law abuse, it is important to know how to file a complaint with the appropriate authorities. The FBI provides guidelines for reporting color of law abuse, including the following information. Identifying information. Provide detailed information about the victim, including their identity and any relevant details that can assist in the investigation. Subject information. Include as much identifying information as possible about the government officials involved, such as their positions, rankings, and the agencies they belong to. Incident details. Specify the date, time, and location of the incident, providing a comprehensive account of what transpired. Witness information. If there were any witnesses, whether public officials or private individuals, provide their names, addresses, and telephone numbers. Chronology of events. Present a chronological summary of the events that transpired, offering a clear and concise overview of the case. Report numbers and changes. Include any relevant report numbers or case identifiers that may assist in the investigation. It is essential to contact your local FBI office by telephone, in writing, or in person to file a color of law complaint. Additionally, you can send a written complaint to the United States Attorney's Office in your district or the Assistant Attorney General, Civil Rights Division, in Washington, D.C. The FBI conducts investigations and forwards the findings to the appropriate U.S. Attorney's Office and the Department of Justice, which determines whether to proceed with prosecution.
All right. If you can see my screen, hopefully you learned something. We're going to come back to it. If you can see my screen, here's some verbiage that one could potentially use on a bond. Now, I am going to make sure that everybody gets this. First off, before I go into it, who doesn't see my screen?
I don't.
You can't, okay. If you can't see my screen, inside the link that I sent to you for class, there's a link you can toggle on, which will bring you into our space where you can actually see what I'm sharing. If not, then you can just sit tight. I am recording this particular course, and I will bring it, into the space where you actually will get access to it. I don't think you're in our Bitrix space yet. So, if you can't see it, it's because you're not on the link to be able to see it, but I'll read some of it to you so that way you kind of get the gist of it. I use this verbiage pretty often because, in my opinion, this verbiage kind of says everything. You see here where it says basically we, and it has the real person's name, principal, real man's name, surety being creators under juror status of sound minds, standing in honor with full knowledge and full disclosure with honorable intent, herein hold, bind, obligate ourselves individually and cooperatively, jointly and severally as voluntary sureties for the herein named account holder, and accounts, each jointly and severally for any amounts up to and including, and this one here is already slated for $300 million in United States dollars, for the honorable purposes through this bond of underwriting, insuring, and indemnifying said account holders and accounts against any and all pre-existing current and future liabilities through / by offsetting against this bond dollar for dollar all such obligations which shall include but not be limited to any of all underlying related accounts. And this is where the fun starts. Now, everything that's from here to here, in my opinion, kind of sums up what one might run into. Relating to accounts, agencies, bonds, persons, both public or private, whether named or unnamed, for all aiding and abetting acts, actions, whether civil or criminal, for the recording, whether civil or criminal, accusations, acts of God, advisements, affidavits, affirmations, absconding, admiralty actions, arrests, activities, attestations, accidents, appointments, accords, agreements, bills, breaches of contract, bonds, bankruptcy actions, borrowing, brokering, and the list goes on and on. I think this kind of, you look at it, kind of covered what one could potentially run into commercially. And it's not an all-exclusive everything, but it had just enough to make me sleep good at night. So good at night that they say if it ain't broke, don't fix it. Tim Turner wrote this document. And I told someone once before, when I first got exposed to this information, I was too stupid to stop. But this is a good framework, in my opinion. I'm showing this to you for demonstration purposes. If you feel you need to put one of these together and you're new to this and this seems like you might need a lawyer, then by all means call one and let me know how that turned out for you. But pretty good start. Is there anyone in this class that's ever seen these green bordered, red bordered certificates before? Anyone ever seen them before?
It looks like something that might be around your birth certificate or something.
Mm-hmm. Right. And the reason why I'm saying you seen these before is because when I first got exposed to this information, this was what used to be taught to those who were actually engaged into this. I just find it ironic that let me just look through this bond just for laughs and giggles here. Because someone said, well, Mr. B, it doesn't cover accounting. And I was like, oh, yes, it does. Isn't the first one where it says it covered accounts, related to accounts? Isn't that accounting? I get it, though, But anyway, I just found that if you kind of stick to the fundamentals, everything kind of makes sense. But it's got to make sense to you first. Good luck if you try and explain it to somebody else when you don't understand what this stuff is about. Who has their chat GPT up? And if you do, type in what is the right of indemnity? And don't worry, I'm gonna do it with you. So I'm just curious. I was doing something earlier. We'll come back to that. Maybe. I don't know if y'all ready for that yet, but we'll see. You guys can still see my screen, right? Or it's still y'all still seeing the verbiage. So let me see if I can bring y'all to the light here. Maybe I can bring y'all to the light. Bring you to the light. Nope, not going to be able to bring you to the light that way, so I'm going to bring you to the light this way. All right. You should see my screen. What is the right of indemnity? I know I spelled it wrong. Just bear with me. Let's see what we get here. But they just right, we should get a response. Says here, the right of indemnity refers to the legal principle that allows an individual or entity to be compensated for a loss or damage that they have suffered. This right is often exercised through insurance contracts where the insurer indemnifies the insured against potential losses. In a broader context, indemnity can also refer to a contractual agreement between two parties where one party agrees to compensate the other for any loss or damage that may occur in the future. This is often seen in business contracts where one party agrees to indemnify the other against potential losses arising from certain actions such as negligence or breach of contract. The purpose of the right of indemnity is to what? Restore the injured party to the position they were in before the loss or damage occurred. It's important to note that indemnity typically covers actual losses and not intended to allow someone to profit from a loss or damage. So, when you contract properly, you should be, in my opinion, creating a right to be indemnified and allow an arbitration clause to be implemented to make all parties whole. Does that make sense to everybody?
Yeah.
All right.
Yes, absolutely.
So when you look at contracts, when you're asking these public officials for a public hazard bond, that's why you're asking for this, because everybody in commerce has the right to what? To be indemnified. And if you're pulling me over, if you're asking me where am I going in such a hurry and all this other stuff, and you got lights flashing, I have a right to see your public hazard bond. And your failure to produce it is prima facie evidence that you're committing tax fraud. And I have to immediately, when I'm able, if I'm not being taken down and beat over the head and this, that, and the other, I have a right to do a UCC to protect myself because I ran up on this fool that didn't have no what? Insurance. Or at least he didn't show me he had proof of insurance. Are we clear?
Yeah.
Okay. Who isn't clear on what I just explained?
I mean, that's just like getting into a car accident, though, right?
Correctamundo.
You get into the car accident, you request for their insurance.
Exactly. This is why whenever public officials show up on the scene commercially, they had to violate something of yours to do so. So go ahead and get the pen and pad ready. I know a lot of people say, Mr. Bay, it almost sounds like we're ambulance chasers. Not on the contrary. There is a reason why I deduce my movement, and this is just Bazell being paranoid. In a 7-day cycle, I deduce my movement to 1 day a week. The reason why is because not for me, but for them. Because I know me, I've been wired this way. I couldn't move like a lot of how you guys move in the public. It'll drive me nuts. I couldn't stand it. Now, don't get it twisted. I have quite a few students who have mastered this thing pretty good, and they love it. So that's their new occupation. They're just going out here and seeing what kind of claims they can enforce. I'm just saying. It's a yin to a yang. Case in point, right of indemnity. I find it equally strange that all corporate fictions, they wear this right of indemnity like a Superman badge, an S on their chest. And we ain't really caught on yet. How many of you guys understand what the word mortgage means? Let's say the word mortgage. Mortgage is a two-syllable word. So the first syllable, more or mort, could easily represent death. Engage represents pledge. So there you have it. A mortgage is a dead pledge. Now, the reason why mortgages are popular commercially is because it's like going to Vegas knowing that if you roll that dice 12 times, you're going to crap out. And their job is they all know what time you're going to roll and crap out. So their job is to keep you buzzing, keep you happy, drinks on me. So the house, because if you keep playing the house, eventually the house wins, right? The object of the game is to go there. Now, that's again, not you as the gambler, but the house is to keep you entertained. Keep it coming. You have to have an enjoyable time while they rob you blind. It's not theft. You had a great time. Lost a few bucks, but it's going to spend it anyway. Might as well have some fun. See, as long as they can keep the environment favorable, everybody is there doing what they want to do. With this information, understanding you have a right to be indemnified, what do you think you have a better chance of being indemnified? As a sentient soul, living, breathing man on the land, or a legal fiction who has rules that are written in its favor to go to and fro commercially? How do you think the game is rigged? Is it rigged for the natural man, or is rigged for the legal fiction?
Legal fiction.
Okay. Now, listen to me carefully and no one get offended. If the rules of the game are rigged for legal fictions and you're out there in commerce as a natural man and they decide that they want to try you, tie you up, kidnap you, and do what they do, who's in the wrong?
The man.
So now, when you don't know that, what do they say? Ignorance of the law is no excuse. Now, you're the man on the land and you don't know that it's commerce, and you keep running into people's stuff and keep being jammed on this, that, and the other. Pain is an indication that something is wrong. Pain is not a bad thing. The Most High gave you the ability to experience pain to let you know, wait a minute, this ain't right. The bad thing about pain is when we're ignorant, we keep doing things so much that our nerves get seared. So things that's supposed to hurt us don't. And a lot of us in commerce, We have been doing stuff so long, so wrong, that our nerves are seared. It's normal. I find it strange that we live in a world today where if I was traveling on a highway and there was a woman who was stranded, distressed, broken down on the highway, most people find comfort in passing that person on the side of the highway than pulling over and offering them help. I find it strange. I also find it questionable. I also find it even more strange that more people will pull over on the side of the road not to offer her any help, but pull out their cell phone and put her on YouTube. I find that even more strange. So I don't know what I'm conflicted the most with. The fact that men will pass and won't stop, or the ones that do would rather put it on YouTube than to offer help. I don't know. Maybe this is the sign that I'm maybe getting, I'm becoming my elder. I don't know. I just find it strange. With that being said, how do you think the right of indemnity works for agencies that know that they're purposely doing stuff that is going to cause you loss and damage? How do they get away with being brought to task and being held accountable under the right of indemnity? How do you think legal entities legally get away with what they get away with if everybody in commerce has the right to be indemnified?
Because of lack of knowledge.
Lack of knowledge, beautiful. That's one. But I'm gonna kind of twist the knife just a little bit because I like where you're going with this. What do you have to do to demonstrate that you wasn't injured, even though you was injured? What do they tell you in law that constitutes no injury? It's in the legal maxims. Starts with a C. Sort of like it says, he who can what? Can receive no energy. No injury. He who consents. So how they get away with it is that they have you consent. I'll go here. When I was a child, I remember when I was in grade school, they used to have the little toothmobile, like the bookmobile, that would come out to the school, and they would give all the children these little fancy toothbrushes, and they passed out fluoride pills. And I remember them telling us that the fluoride is good for you. It'll keep your teeth clean. But every time we took the fluoride pills, I knew I got a headache, like instantly. Time I swallowed it, it touched my tongue, instant headache. Now, later I found out that even though they'll tell you that there's poison in the water, as long as they don't call it poison, they call it that 15th letter medical term, and they print it on the bottle, and you consume it, and they give you high blood pressure and sugar diabetes. Well, you consent it because you bought it. And even though you didn't read the label and it ends up taking you out of here, they ain't liable because you consented. So the power of consent works just as hard as the right of indemnity. So what they do is they get you to consent, which brings us to your solution in commerce. All of you guys that are receiving awards for arbitration, really sit on the edge of your seat now and listen to the words that's going to come out of my mouth. In the public, most bonded and insured institutions understand the right of indemnity and the power of consent. And how they get away with doing what they do is they manipulate those parameters. you will receive a credit card statement in the mail. And it'll say, you owe us blah, 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 blah. You owe us blah, 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 blah. You owe us. They got to at least say it 3 times on the bill. Then after they say it, they're going to say, please use this voucher and remit with payment. And that voucher's got some information on it, like you owe us blah, 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 blah. And there's an account number on the bottom of it. If you ever used a coupon or a voucher before, like, you know, you reading the Sunday paper, they got bleach. If you use this coupon, the bleach that you normally would pay fiat for is free if you present the voucher. So you go to the local store that honors that voucher and you grab the bleach off the shelf, and then you go to the cashier and she scans the bleach. And if she knows about the sale, she'll ask you, do you have a coupon today? And you say, by course I do. And you literally get the you hand her the coupon, she scans the coupon, you walk out with your bleach. How many of you guys ever done that before? And you guys ever used a coupon or a voucher in commerce before for anything? Ever?
Yes,
ever,
sir.
ever? Okay.
Yes, sir.
All right. So a coupon or a voucher is a form of payment, right?
Right.
Okay. So if they send you the actual form of payment, which is the voucher, and you don't send it back, but you reach in your pocket, you reach out for the debit and credit card, you go through all of that, what do you think they're going to do with the IRS? Oh, by the way, I'll tell you what they do with the IRS. They said, look, we gave this fool lawful legal money. They didn't return it. So the cash they gave us was a gift.
Mm-hmm.
And the beat goes on. So let's re-engineer that. You know they're supposed to be using lawful legal money, so what you do? You do an invoice. You owe the estate, blah, 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 blah. You owe the estate, blah, 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 blah. You owe the estate, blah, 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 blah. Then you give them a bill of exchange. Please endorse and send back to us. Your failure to return will constitute payment in full, and it will constitute a 1099-C for the cancellation of this debt. Process is done. Everybody's happy. Remember, your safety is in the private. You ain't got to make nothing liquid. That's their job. Who doesn't understand what I just explained? Oh, don't say you understand and don't now. I'm going to be upset. Don't tell me, I got it, Mr. Bay. And then it's like, you said you had it. Everybody got it? I got no hands being raised?
No, go ahead, repeat.
If you are in commerce and you call yourself competent and you know the only thing you can do in this debt credit-based system, because it's designed on debt, quote-unquote credit, since it's based on credit, it can only receive credit. Quit trying to disturb the groove of going against the grain. Do you understand?
So what you're basically saying is go ahead and sign the coupon or the voucher, the penalty of perjury, and return it.
There you go.
And then file your 1099-C on it.
Beautiful. Now
that means that people are filing 1099-Cs, on a very consistent basis.
There you go. Because
every month, basically, if you do
every month. Now, for those of you that are notaries, there is some wisdom in what I'm saying, because you guys have been drilled and groomed in this for the last 6+ months, some of you guys longer. For new people, I don't want you to hurt yourself. I just want you to listen. Debt is not debt until it's been on the book for 90 days. So I'm going to give you two ways of looking at the same thing. I am saying the same thing. I just going to sound different. All right. What I'm saying is when it comes time for you to make your payments in commerce, make your payments like you've been making them, but use the coupons and vouchers the way they were intended. For example, if you send in the fiat payment, before you send it, record the fiat payment. Mr. Bay, what do you mean by recording it? Listen to me carefully. If the bill is $150, get a Ben Franklin. Who's on the 50? I forgot who's on the 50. But get your Ben Franklin or whoever is on the 50. Make a copy of it front and back, record that serial number, do a CTR on it, and then give it to them that way. And then turn that voucher into a what? Money order. Watch what happens. If you do it that way, guess what you'll get back from the IRS 30 more days? That 150. It'll come back like a boomerang. Now what you doing? Now that you done got the credit from the IRS, you put the IRS's routing number and account number or voucher. Matter of fact, doesn't the IRS offer a 1040 voucher? I'm just saying. I'm saying you can do it that way, and I have quite a few fiduciaries who learned the old school way like I did on how to do that. Now, for all you guys that are a little bit more savvy, debt isn't debt till it's been on the book for 90 days. So go back 90 days from all those fiat payments you made before that you didn't get back and recoup that credit and start applying it on your next 90 days payment. I'm saying the same thing, just two different directions.
And you can recoup it through arbitration process. Is that what you're saying?
Yes, you can. Yes, you can. You could literally gather up all of your Article 9 security interests that you will deem as receivables, itemize them for K1 disbursement, and then hold a proceeding, record it in the journals, and get to work.
Got it. Okay.
This is why the way we're doing the case syllabuses literally is like your own cryptocurrency platform. It's literally an interactive ebook that will connect to my ebook, that will connect to others in the aspect of ledger to ledger transaction. Is everybody clear on what I'm explaining?
Yeah, that makes sense.
Beautiful, beautiful, beautiful. Before we jump into the next aspect of this course, who has any questions before I go into a little bit different direction? Do we have any questions? Last 4 digits of your phone number is 3722. Let's see. Brother Antoine, is that you?
That's me, brother.
All right, talk to me, big bro. You got any questions for me?
That same scenario, how would you do that recording if that was a debit transaction?
Debit transaction. Or debit or credit transaction, either way. All right, so explain to me the recoupment of debits, the recoupment of credits is if I need a credit coming back, I record it as a negative.
No, that's not what I'm talking about. No, I'm talking about in the same construct. If we took the Federal Reserve notes and we logged in a serial number, the same example you just gave, but instead, if it wasn't Federal Reserve notes, it was if that was done through a debit.
There's an account number attached to that. There's an account that's associated with it. Record the account number with it.
Okay. That's what I want to know.
Gotcha. And I know you didn't ask this, but if you record the account number, you can also issue credit off up in the form of a letter of credit on a UCC-5. You didn't ask that, but I just figured I'd throw that in.
Wait a minute. Say that one more time. About that account number?
You can actually issue credit from that on a UCC-5.
Okay.
All righty. Any other questions?
Quick question. When you say you record it, you said take a picture of it and then write down the serial numbers?
Yes, sir. And then after you do that, you put that on the CTR.
All right, thank you.
Any other questions before we jump into a different part of the lesson? All right. Keep listening, because if you listen long enough,
Somebody wants to know what a CTR is.
Somebody wants to know what a CTR is? A CTR is what we call a currency transaction report. Let's see. I think I can show you one right quick. CTR looks like this. Let's see. CTR. Yeah, CTR. This is CTR right here. Let's see. I don't know if you guys can see my screen. I'll bring it up. Here's what a CTR looks like. You guys can see my screen?
It's twirling. Yes, we can see it.
All right. This is a CTR. So you would record those bills, get them recorded on this CTR, then get it recorded, and then make your submission, so that way you'll be in compliance instead of outside of compliance.
And you submit this to the IRS?
Submit this to all authorities that have an interest in your Article 9 security interest transaction. This currency transaction report should not be filled out for suspicious transactions involving $10,000 or less in currency, or to note the transaction of more than $10,000 is suspicious. Any suspicious or unusual activity should be reported by the financial institution in a manner prescribed by its appropriate federal registrar regulator or BSA examiner. See instructions item 37. If the transaction is suspicious and in excess of $10,000 in currency, then both a CTR and the appropriate suspicious activity report form must be filed. In situations involving suspicious transaction requiring immediate attention, such as when a reportable transaction is ongoing, the financial institution shall immediately notify by telephone appropriate law enforcement and regulatory authorities in addition to filing a timely suspicious activity report. Who must file? Here's the money shot. It say each financial institution other than a casino. Let's stop right there. How many of you guys think you're persons? I used to think I was a person. Well, let's see what they say. A person is a what? An individual, a corporation, a partnership, a trust, or an estate, a joint stock company, an association, a syndicate, a joint venture, or any other unincorporated organization or group. So damn, if I call myself a person, I'm a financial institution. So all persons / financial institutions need to be doing a CTR. Forget what you heard. Now you're seeing it. Now you can't unsee it. So if you go out here and do stuff and get all caught up, Ignorance of it is no excuse. Every financial institution other than a casino, which instead must file a Form 103, and the post office. These are the only two institutions, a casino and the post office, the only one that ain't supposed to be doing CTR. Y'all didn't know that. Y'all didn't know that?
No.
Okay, but now you do.
Give thanks.
And so
that means actually
go ahead.
No, I was just going to say, so that means the person is the one that should have been doing the CTRs before you even engaged with the casino.
Exactly. Because the casino takes your fiat and they give you tokens. Yeah. See, as long as they got the game, they're showing you the game. You just ain't playing right. Yeah. They're showing you how to create negotiable instruments, tokens, and all that stuff. When you go to the casino, you take your fiat and you exchange it for tokens that you can spend in the casino. Keep the game going. Create you some paper and play the Monopoly game. That's what this is.
And when you do it that way, it really is entertainment.
There you go.
Never looked at it that way.
The devil is in the detail. Any other questions before we turn up?
What's the Form 103?
Form 103 is basically just like this one, but it's exclusively for casinos. Form 103 is a currency transaction report. These reports are filled out every time you swipe your debit card or credit card. Every time you go to the bank, every time you're doing stuff in commerce, one of these reports are being filled out. But here's where it gets funky. Because you're making all these transactions and you ain't doing no accounting, you're out here creating suspicious activity reports, especially if you made more than $10,000 in fiat in transactions. So if the bank got a CTR and you don't, you're in trouble. That's dropping without insurance. You're liable. This is why if anyone wants me to send anything that's going to create debt derivatives, I ask them to show me the last 90 days CTRs for the account that's in question. If you do that, I give you all the fiat you can stand. But if you can't show me that, good luck with that one. Ain't nobody got to convince me the devil real. I done slept with the devil, done ate with the devil, done bathed with him, done sat with him for 7 years in the penitentiary. So please understand and know that this is not checkers, it's chess. And they got to tell you what they're going to do before they do it. They're going to tell you up front. Anything you say can and will be used against you. You can't break a law. Everything is commerce. You want to deal in drugs, get you a freaking license. And we can make all the drugs you want. You can start a pharmaceutical and we can make tax money off of it. But if you go out here fumbling and trembling in this commercial system, here in the United States, this is one of the only countries in the world that anything that you can say is illegal, they'll let you get a license to do. If you can name it and you deem it as morally unethical and illegal, there's a code that lets you get a license to practice it. So when you fail to do that, the penalties are severe. But the 103 is going to be one of those other forms that the casinos use. The post office uses a different form. The BSA stands for the Banking Secrecy Act. Under the Banking Secrecy Act, they have to keep track of who receives those Federal Reserve notes. That's why they got tracking numbers on it and money strips and all that stuff. I'm going to just hide mine under the mattress. Good luck with that, too. If you want to know what code you need to do to know what to send it at, here's the codes right here. You got a code for the Comptroller of Currency. You got a code for the FDIC Corporation. You got a code for the Federal Reserve. You got a code for the Office of Thrift Supervision. You got a code for the National Credit Union Association. You got a code for the SEC. You got a code for the IRS. You got a code for the USPS, Postal Service. You got a code for the Commodity Futures Trading Commission. You got a code for state regulators. Pick your code, send in the form. You ain't gonna have no problem. Playing without this form, throwing rocks at the chain gang. Are we clear?
So every time you use currency, you got to trail it with a form.
CTR, need to have it. Need to have it. All right. Okay, I think I got some folks that's trying to definitely get in. They got some questions, so here's what we're going to do. Let me stop the share. Share stopped. I'm going to unmute everyone. So I'm going to ask everyone to mute themselves. If you have a question, unmute yourself and ask the question. I'm going to try to go about it this way so everybody can definitely get what they need to get in. So I'm now unmuting everyone. And so let's start here. And open them up here. Everyone is being unmuted. I'm asking you to mute yourself. And if you got any questions, unmute yourself and ask your question. Okay. Everybody's unmuted. Ask your questions if you have any. Any questions?
Yeah, I got a question. So when you use the CTR, you're going to submit this to the corporation.
Here's for all of this. Let's point the new notaries in the right direction so you don't get yourself in trouble. Notaries, when you do your CTR, you need to hand that CTR to another notary first. Let that notary record it in their commercial journal first. And then it needs to be recorded by another notary. The reason why you do two notaries is that's a court proceeding. Now, getting it over to the public is real easy. You just got to give them notice that it was done. Are you clear?
You said have two notaries.
Fill out the CTR, and then go before a notary and have it attestated and create a jurat page so they can record it in their journal, that transaction. And then go to another notary and have another attestation and a jurat done by a second notary.
Grace and peace, beloved.
Okay.
Peace and love, big bro. I know that voice. What's good with you, man?
And then once you do that, then you send it off?
If you need to. In certain instances, you may need to make sure that the runway is clear when it comes to reporting. Most debtors are in the proponent where debtors have never been responsible fully in their transactions. It's always been they're a beneficiary. They want to benefit. It's my money and I want it now. Now, what has actually been created is this: you've been enabled. So what I'm saying to you is when you go from being a debtor to a creditor, when you're a debtor, these institutions are actually doing these things. Brother Kasik, are you still with me, big bro? You still with me?
Grace and peace. I'm here, beloved.
Man, I know you can't give out legal advice being a former banker, but from your perspective with CTRs, explain to the new people the importance of CTRs in the banking sphere.
Well, keep it short. If you don't have a CTR, you have war script.
Wow. Say that one more time.
Say it again.
Say it one more time.
What was the last part?
If you do not have a CTR, you have war script.
You have war script. Okay. There you go.
No said. Okay, I got you.
What people don't realize is that the Civil War was a war amongst families. They talk about their families, but they don't talk about the Civil War that happened amongst the tribes. It was families that got split on both sides.
Right.
And so, in essence, to make everyone happy, they made everyone slaves. You have to remember, you had to transition from, what was it, we've had how many different banks, national quote-unquote banks, before the government stopped quote-unquote creating banks.
Right.
And so at each failure, they modified the system. From the beginning, we were operating as each independent bankers. We went from everyone doing their accounting in their house and they're being responsible. And if you get your accounting wrong, you went to jail.
Correct.
And that's why they called you Lord of the Manor or Lord of the Estate, because you are the one responsible for everything.
Right.
And so at the end of the Civil War, what did they do? They gave everyone one currency. Every time we go to war, what do they call it? The greenback.
Right. It's a unification of currency.
It's a war funding mechanism.
Right. War funding mechanism. Most wars, if you can articulate the war verbally, are bankers' wars. You got to understand that there's a reason in the aspect for new notaries to understand the importance of CTRs. You want to understand that in the space of commerce, under the Banking Secrecy Act, these institutions are chartered and governed to track who's using that military war script. And even though you might have not known that, that doesn't mean that makes you fully immune from it when they decide to pull your card.
Do you remember, was it World War One, World War Two, I believe. They began the greenbacks. It was a bond to fund the war. But once they got off the gold standard, right? What happens is the fiat of choice becomes that war bond. That's why it's backed by bombs and bullets.
Exactly. Bonds and bullets. There you go. The key that you guys want to remember when stepping into this information, and again, Brother Kasik, former student, I think I got Brother Aaron there, man. These guys have pioneered a lot of things in the notary space. And there's a lot of information that just isn't talked about, but is known. There's not.
That's because the game is sold, not told, players.
Right, it's sold, not told. There you go. It's sold, not told.
And wealth whispers. That's my family secret.
Right. It's an understanding. And you were purposely given the most explosive, toxic derivative. Now, remember what we start this class out with. My question still poses. Why do you think the institutions that demand payment have to be bonded and insured, and you who are being demanded to pay, you're in a lot of instances in commerce. Now, I ain't going to say you're not bonded and insured. Let me say it the right way. You don't control the bond and the insurance that governs your commercial energy.
Because there's a maximum law that says the law doesn't protect the one doing the deceiving. It protects the one being deceived.
Correct. That's a maxim. That's the maxim. You understand that there are principles. This is why I brought back into the fold in the class the right of indemnity. You have in all commercial transactions the right to be indemnified. Now, your failure to execute upon that, constitutes consent. And another legal maxim is that he who consent can't be injured. If you consent and they beat you over the head, then you just got beat over the head because you consented to it. Still hurt, but you consented. So institutions hide behind the fact that if they can get you to consent to the torture, the pillage, the extortion, then no harm, no foul.
In defense of my shameless institutions.
Yeah.
It's clearly a constitutional 13th Amendment right that they don't understand.
I agree. I agree.
And so if they don't know that that slavery is not legal but involuntary servitude, which is an upgrade from slavery, just in colorable language only.
Right.
And that's what Kanye meant when he said slavery was a choice.
Right.
Because at the end of the day, you choose whether or not you're going to get up and get beat or you're going to attack the master and die.
Correct.
We all have choices. And where we are in our lives is a combination of every single choice we've made. For instance, taking it back to the CTR. Why do you think Hunter, I'm not going to say the last name, but why do you think Hunter's in all this trouble? He received money and the bank did a CTR. He didn't do a CTR, and it did, and so the bank sent out a SAR, which notified the IRS.
There you go.
The investigation. All he had to do the CTR, but then he didn't want. Well, let me be quiet.
Yeah.
I'm April.
Right. It makes sense. The whole aspect of CTRs, there's a governing proponent in commerce. And what I want you guys to learn as notaries coming up in these ranks, especially on the birth and the exception of this new AI technology, you need to understand that this is a system of systems. And you have the ability, if you're looking around and you're looking at my system, you're looking at Brother Kasik's system, you're looking at Brother Aaron and everybody else that has a system, and you're like, well, if they got their own system, then I think there's room for me and my family to have a system. That type of thinking will take you far. And there are contracts, projects, treaties, whatever you want to call it, for commercial purposes where there's strength in numbers. So if we're all talking about trusteeship and doing things from a lawful legal perspective, we can get into a very interesting conversation.
Community law, international law.
Right. We can get into a very interesting conversation in that. And so these things definitely have room in the dialogue. Financial literacy, in my opinion, should not just die quietly by the fireside. It should be something that if you were not blessed to have it as a formidable foundation, and if you're in these type of course of studies, this is an opportunity for you to add that pillar to your foundation. Financial literacy is going to reconnect you to all these things that everybody knows, But there's, like my brother just said, the game's got to be told. It's got to be sold, not told. I find it ironic that if I give you this information for free, you won't respect it. I start putting a price to it. Now you hold it to your chest.
I didn't believe it, beloved, and I put it into action. Man, you know what the magic? It's funny. The higher the price, I started off giving trust for free. Then it went from 500, 1,000, 2,500. Still wasn't getting no one they didn't understand what the trust didn't change now. Nothing I did change. But once I hit the 10,000 a trust mark, they started understanding the value of what I gave them. And the people that paid 10,000 are in 3 months are 5 years ahead of the ones I gave it for free.
Case in point, we place a value on information from a certain perspective. And if you understand asymmetric information, insiders in a space, they make money, they blossom, they profit by sharing asymmetric information with those that can capitalize off of that intel.
That's the first capitalism. Capitalize.
That's the whole aspect of asymmetric information is what you have been wrestling against, trying to figure out. When you're talking about going from the public to the private, is mastering certain aspects of asymmetric information. And I'm going to say this until I'm blue in the face. Now that they have publicly released non-developers access to this AI technology, they're testing these models to see how much asymmetric information is being circulated. Because if you've been using ChatGPT, myself, I've been using it before it was released with our banking platform, but chatbots are not new. But the model where it tells you this AI model knowledge base stops at 2021. There is a reason why that initial model knowledge stops at 2021. I'll go here to show you what I mean. Being born in 1973, in 1974, price of gas was right under 50 cents a gallon. What is the price across the board average for a price of gas right now? A gallon of gas, average.
About $4.
$4.
Yeah.
So if it's $4, so listen to this. How many 50 cent is in $4?
Four.
Say it again, because I heard 4, I heard 8.
It's 8.
Somebody said 8. 8.
Yeah, 8.
Okay. So what that means, if your dollar didn't grow by 8 times in value, this is how far behind you are in your accounting. You're not getting any more gas. You're getting the same gas. Your dollar was tethered to something, and then it wasn't. And now you're in this mechanism where people rely on something else telling them whether something has a value or not than actually acquiring the good old standard gold and silver, putting it into a trust, utilizing the good old standard. What do governments do when they fiat tank? They put stamps on it. They got documentation right now. Before AI came out in everybody's hand, These manuals that I've been selling to you guys, which were written by private attorneys and so forth, they tell you specifically down to the cases where they have case after case after case with the Bank of International Settlements, where they have tried, true, and tested. Whenever a family loses faith in the currency system, they repatriate their dollars with a standard, either gold, silver, and stamps are used commercially. And it amazed me that most individuals, when I started talking about CTRs, that information didn't go past certain families in certain rooms. The AI technology tethers off at 2021. Why? Because if you pull certain cases and you put it into that chat GPT, even though it'll tell you they can't find it, it's certain institutions that have records with the SEC, that has records with the Edgar website, that has access to cases with the IRS where it will cross-reference those cases. And they cut the model off at 2021 because you just might figure out what actually happened and how it happened. Remember, the dollar has to be at least, I am 50 years old. So every year that comes and goes, the previous year, I have to make double the money to keep the same standard of living. So my platform has to double to keep the same standard. That's a prerequisite.
May I share
Go ahead.
Because you asked a question earlier on why they don't know about the CTRs, and
right.
I can tell you why.
Mm-hmm.
They don't know because they've been told the wrong information. So
right.
The uneducated tellers will just say that it's because the amount they need the CTR. I mean, they need to gather this information, right?
Right.
Well, what people don't know is I have to tell you I'm doing a CTR. I do not have to tell you I'm doing an SAR.
Right.
And with the CTR, people think it's, I'm avoiding taxes. They think it's a tax thing.
Right.
It's not necessarily a tax thing. It can become
a tax issue. Right.
Because it's designed to stop money laundering.
Right.
Money launderers don't do CTRs.
Beautiful.
And so when people are always trying, there's something called they have us look out for structured transactions.
There you go.
What a structured transaction is say I have $20,000 I want to deposit. I don't want to do no CTR.
Right.
So I'm gonna go to this branch right here and deposit $8,500.
Right.
I'm gonna go next door to another branch and deposit $5,000. I might go
right. Right.
What you don't know is as soon as I see that you're making multiple deposits.
Right.
Within, I believe it's 72 hours is where
72 hours.
Where the flag was.
Mm-hmm.
If I see any deposit that accumulates to 10,000,
right,
within 72 hours, I don't have to tell you shit because now I'm doing the CTR for you and I'm putting an SAR on top of it.
SAR, exactly.
And that's when it becomes the tax issue because
that's when you have and you just hit the nail right on the head. The thing about underwriting, and I tell clients this when we look at their books, especially when we're looking at ARs and APs, and I see you're moving a lot of money between your personal and checking. I try to tell clients that, okay, understand that the rules of commerce are set in provisions where businesses are given a certain level of leadway. Like, we kick the word disregarded entity around like a dirty sneaker. Truth of the matter is, an LLC is a disregarded entity by design, but the managing member isn't. Now watch this. You got all these LLCs that you got, and these are all, by design, disregarded entities. So let's look at the same analogy that you just gave. You got an LLC that has 10 accounts. They got an account with Bank of America. They got an account with Wells Fargo. They got accounts with all the big boys.
Well,
they got...
found the loophole.
Mm-hmm.
You found the loophole.
Mm-hmm.
I can't see the deposits made at other banks.
Right. Remember, the LLCs who are disregarded entities with these business accounts, just like Brother Kasich is explaining, you can see what's in that family tree. You can see all Wells Fargo transactions if you're all in Wells Fargo. You can see all Bank of America transactions if you're all in Bank of America and Merrill Lynch. But you can't see what's in the other.
There is one exception. In my due diligence, I found that Ally Bank is putting transactions, like deposit amounts, on early warning services reports. So I would recommend the account's not negative.
Right.
But they're reporting the balances to early warning services.
Right.
That's not supposed to happen.
That's not supposed to happen, but remember, under current expected credit loss provisions, it's easier for them to make the client liable than in them to have to take a hit accounting-wise for violating general accepted accounting principles. It's an easier way. It's like, okay, if I'm the bank and you're a terrorist and the van that you use to pick these little people up was financed by my bank, and I kind of knew that's what you were doing, it could get sticky. But if I just simply say, well, he had a legitimate LLC, everything looked legit, well, now I heard he was doing this, that, and the other, but I didn't have no dog in the fight, and I didn't see any of that with this van that he bought. Did I find it suspicious that he bought 50 of them? I don't know. Anyway, case in point, institutions have a way, because I'm going to tell you as an accountant, we are all taught to ignore things. As an accountant, if it doesn't fall in the gap, I am legally allowed to ignore it.
As an accountant, I need to ask you a question.
Mm-hmm.
When's the last time you went into the bank?
Never. I haven't been. Let's be back. I haven't been in the bank. Oh, let's be clear. I've went for others. So please clarify the question.
When's the last time you was inside of the bank?
Inside of the bank for myself, for others.
It doesn't matter. I need you to have the visual.
Last time I've actually been inside of a bank was probably post-COVID.
Okay. Do you mind telling me which bank?
Last bank that I went into was, what do they call that bank? It was BOA, Bank of America.
Beautiful. That's exactly what I had in my mind. That was the last bank I went to. Now, when you go to B of A and you go into the bank, you see how they always have the long line that goes across the bank?
Right.
And the one line that goes straight?
Right.
Do you know why?
Do tell.
People get treated differently for the different lines.
I agree. That makes a lot of sense, right?
So that is because so I started going to that line, Bank of America line. I was working? Burger King. I was an overachiever, so my manager didn't do anything, and so I literally ran the entire Burger King. So I was making bank deposits.
Right.
I was doing everything else. That's when I first got introduced to CTR.
Right.
what people don't realize is on the business line, you get treated better because, one, they expect me to deposit cash.
Exactly. You're there making regular scheduled deposits.
On top of that, when you on the regular line make cash deposit, say you deposit $100,000, the bank don't make money for that.
That's right.
Every time in a month, if I deposit more than $25,000 cash, the bank makes 10 cents off of every $100. I'm cool with that. The reason I'm cool with that is because now they're expecting random people making deposits, and the CTR is for the corporation, and they just know that whoever grabbed the bag.
Right.
And that removes the liability from anyone delivering the cash.
Right.
And I have a business license, and in the case of my business is owned by my trust, and so
that's right.
There's no one person that got the license.
That's right.
Tactically built so that there's 3 levels before I come in as a beneficiary.
Right.
Or trustee.
Right. That basically, and that definitely shows diversification also, because the premise of accounting with, and there's a couple of real good cases I can definitely refer you to in these type of transactions, especially dealing with banks and trusts. The literal sense, CTRs should be a regular practice for fiduciaries because it keeps clean hands and it develops practices that can be further noted and minuted when it comes to certain types of transactions that may otherwise be scrutinized by the various
system. That's beautifully put. I spent a year, best time of my life was in COVID, right?
Right.
When COVID hit, remember when I told you I went traveling in COVID? I just started, that's when I really started to hit the road as a journeyman trustee.
Right.
I spent a year because I was in jurisdictions where people had legal cannabis, they had legal businesses, but they were sitting on warehouses full of cash that were getting robbed.
Right.
And everybody was afraid because every time they moved the cash,
right,
if they get stopped, the cops were using I forgot the term.
They were using technology. We'll keep it safe.
Yes, they were using technology.
There you go.
And they, of course, anything over $300. And it's because they didn't have the asymmetric information. When I traveled, I had no problem. Give me all of it. I don't care how much cash you have. Because I'm going to put it in this briefcase. I'm going to fill out the CTR. I'm going to give you the receipt. I'm going to fill out in front of you a deposit slip, sign it, put the money in a sealed bank bag.
Right.
Put the deposit slip inside, put that inside the bag, put the bag inside my briefcase.
Right.
Lock that briefcase, and then have the CTR on top of it and tell them how much money I have.
Right.
Now, if they decide they want to take that, they're going to violate every single law on the books. And I hope they do that.
Right.
Because that's a funding opportunity for the trust that's just been violated.
Right. Easily.
Where is my pursuit of happiness through the commercial affairs of capitalism? You're stopping my money in the commercial ways when I am licensed and insured to do such.
Right. I have a right to convey.
And I'm headed to the bank, and I can prove it.
Right.
And one thing they don't realize is I learned that in the bank. As long as you use I always order it's deposit bags.
Right. Carbon copy.
No, not the carbon copy. No. This is business cash deposit bags that has...
Oh, with the zipper.
No zipper. No, that's the pouch.
Oh, okay.
it's once I make the this the process, right? So the bank has a relationship with the businesses. The businesses that have high cash values, we order certain products for them so that it's understood. And once the cash is in that product and they're in transit, so if I'm the manager at Burger King, I have the pouch, I have the cash, I have the deposit slip, and I have the giant bag that I told you about. I order the bag with pre-printed on the account number on top, and then there's a seal on the bag. You open it, it's like a tamper-proof seal. You put the cash in there along with the deposit slip inside. Once you seal it, at law, that cash is considered deposit.
It's the clear bags, the clear bags that you can write on.
Some of them are the clear, but I use the ones where you can pre-print your account number on them already. So there's different.
They got some have the inserts too. I know what you're talking about.
Yeah, and you put that inside of the bank bag. Or the where it says Bank of America in gray or Wells Fargo in black. You never just put cash in there. They can take it. That's just a bag.
Right.
But what you just proven is you have a private administrative process between you and the bank.
Yeah, I like that.
Right. These type of conveyances fall directly in line with. I mean, there are numerous nuances to move conveyances. Like most of the notaries are learning now about these M3 conveyances, and just recently, this was right before, like, we're going to back up because this is what I started seeing 90 days ago, and it's wide open now with M3 conveyances. The bureau that was formerly known as the Bureau of Public Debt, now known as the Bureau of Physical Services, always gave notaries the judgment transmittal data sheets. They always gave notaries the transmittal letters, always gave notaries all of the credentials to make withdrawals from the DTCC side of any deposit that was made in the court register investment system. They couldn't tell you what citation to use, but on the data sheet, they give you a list. Now, for all intents purposes, if you are a notary in good standing and you have a judgment package, is what we're going to call it for conversation purposes. That's not the technical name. I'm just trying to take you somewhere if you listen. If you understand that the judgment fund is the alternate name that you call the CRIS, this is the money coming out of what was deposited, the UCCs, the traffic tickets, the child support, all of this stuff. It goes into a DCF, a disputed ownership fund, then it becomes a judgment fund, and then when it's on that side of the ledger, it's now ready to go wherever it's going to go. But it's only going to go based upon the information that's attached on that side of the ledger. So you're supposed to look at, when you do a UCC and an M3 conveyance, and that could be a security agreement, promissory note, bill of exchange. We're going to make it safe for everybody. I'm talking about bills of exchanges now. You're going to have one bill of exchange that's going to go inside of the DTC, which is the CRIS. And then you're going to have a different bill of exchange that's going to come out the other side. They can't give you legal advice. But what they will tell you, I don't think you can see my screen. Maybe you can. But if you can see my screen, somebody read to the class. the citation that they'll give the notary.
Can't see it, Brother Brazil.
You see it? You feel me?
I can't see it.
Okay, I'm finna bring it up. Give me a second. They're going to give notaries this citation. All right, here we go. Sharing the screen. Everybody should be able to see my screen now.
Yep.
They're going to give you that citation. It's up to the practitioner to know how to apply that citation to lawfully withdraw out of the judgment fund. I'm going to back up into your arbitration because they all go together. In arbitration, a lot of the arbitration cases are done on an admiralty claim. Bear with me. That's going to look like this. And this is what I read at the beginning of the class. This is your affidavit of obligation. These are your maxims. My favorite one, number 14. It's tax fraud to use the court to settle disputes, controversies which could be settled peacefully outside or without the court. That key word, or without. Or without could be synonymous with foreign. Keep that in mind. I'm going somewhere. See how we come back to this right here? This is why, as a notary, when we do arbitration, I don't care how the case starts, it's going to end with the fact that if there's an official that's involved, they are required to provide this public hazard bond and information. Their failure to provide this information constitutes corporate and limited liability insurance fraud under what? That's Title 15. If you violate Title 15, this is money that the public can't issue because it's a violation of one of their very own that's supposed to be bonded and insured. So you get to use this citation. Now, I'm just giving you this one because everybody ain't notaries in the class. But as a notary, they're going to point you to, well, in order for you to make a withdrawal, I'm going to show you how they're going to say it and not say it. Everybody in the public, they're going to tell you what you can't do. And if you don't put the right citation, they're going to tell you, well, these funds are not going to be able to come out of the judgment fund. If you associate your transaction with Title 31, United States Code 1304, subsection A3A, then it will flow out. Does anyone have access to ChatGPT so they can tell the class once again what this citation ties to? And don't worry, I'll do it with you. I'm just not putting all the emphasis on you. I'll do it with you.
You want us to put the title into ChatGPT now and see what it says?
Exactly.
Okay, let me open my computer. Hold it.
If I did it right, we should get a response.
Beloved, I have to admit, y'all better than me. I'm still not plugging my data into ChatGPT. I ain't gonna feed that beast. I'm too private for that. If he gets some of what I got.
Brother Cassette, are you familiar with ISO 20022?
I am not.
Check it out. That's the new system that the banks are using right now. I have access to that and everything. Yeah.
We're supposed to talk offline weeks ago. I'm still waiting on the call.
Well, I don't have your direct connect. The last time we was on
I told your cousin to send it to you.
No, they didn't send it.
All right, I'll have my people reach your people. How about that?
Hey, look, don't leave me out of that conversation either. Here's if are you guys looking at what we're populating here, and there's a reason for that. Under Title 31, United States Code, subsection 1304, pertains to what? Judgments, awards, comprise settlements according to the section. Necessary amounts are appropriate to pay final judgments, awards, comprise settlements, and interest and costs specified in judgments or otherwise authorized by law when payment is not otherwise provided for. 2. Payments is certified by the Secretary of Treasury. 3. Judgment, awards, and settlements is payable under sections 2414, 2517, 2672, 2677, and Title 28. I know what somebody's going to say, well, Mr. Bay, when I put it in, it didn't say all of that. I got the paid version. I got a data stream. It's okay. What I'm saying, notaries, is when you take value from one ledger and run it in as a receivable, use this citation to run it out. We're talking about M3 assets going in and K1s coming out. Aren't these payments that are certified by the Secretary of Treasury?
Yes.
Okay.
But I have a question.
Sure, go ahead.
So for one, let's say one M3 asset judgment transaction, that means that we're going to have multiple CTRs?
It will be to your best interest to not look at the CTRs as just a one-shot in the dark. Because I'm going to go back to a fundamental concept.
Every time it moves.
Right. Every time it moves, like if it goes from my ledger to Cassette ledger to Aaron's ledger, I'm probably going to have 6 CTRs.
Yes. Every time, if it's in transit, it's like a train station. That's the ticket to get off the train.
Right. And if you do your accounting right, you can grow it on the books every time it's moved. If you're on your accounting, that's where your multipliers can come in.
Well, I see that part. But so now, does the bank? I know this is gonna sound kind of crazy, but does the bank stay the same, or like what? How are we switching out the bank on the CTR? Because I'm still trying to be cautious as to like documents to put.
Let's talk about the CTRs in an accounting concept, which will make more sense to you.
Okay.
All right. If you, let's say I bank at Bank of America, you bank at Wells Fargo, and Empress banks at SunTrust, just for laughs and giggles. All right. Now you send me $100 into my bank, and then I send that $100 to Empress. How many CTRs do you think are involved in that conveyance?
I mean, a minimum of 2.
Okay.
Well, 3.
Now,
a minimum of 3.
Minimum of 3. All right. Now, it's the currency transaction report is designed to capture that United States GAAP item and hold institutions liable for the conveyance of such item. If it touches an institution in those three institutions where the banks are doing CTRs, now they're doing it whether you're doing one or not. They have to do it internally because there's something they're doing in accounting. But some of the institutions, they are recording the information, but when businesses are required to have multiple books of business, I ain't going to say required, but in your context, I'm going to say they are required. You're a fiduciary. You're not a beneficiary. You're required to have multiple books of business because what I may tell the IRS may be something different than I tell the state of Florida, which may be very different than I tell the state of Georgia, which may be very different than I'll tell ABC LLC. In commerce, we all expect all of us who are competent fiduciaries to have multiple books of business. So the number of banks, the banks changing, is more or less rooted in the accounting method that's governing the transaction. If we're talking about U.S. GAAP, we'll say you're going to have 3 transactions. If you're not talking about a non-GAAP transaction, well, that depends upon the method of accounting, concept of accounting, or the accounting convention that's associated with it. See,
we're doing a deposit.
Mm-hmm.
So if we're doing a deposit into the CRIS. The CRIS, the Court Registry Investment System, as a bank.
Right. Here you need to have for notary purposes 2. I don't care how many banks touch a CTR. You as a fiduciary need to have it recorded outside of your journal in 2 more commercial journals. So that way you will stay on the right side of history. You can have more, but if you have less, you run the risk of being on the inadvertent side of the curve of CECL versus the adverse side. CECL is like the Constitution. The Constitution is a restriction on government. CECL is a restriction on abusive accounting practices. And trust me, fiduciaries who want to do stuff, they know the legal loopholes to do stuff. And they make no bones about, don't get mad at me if I'm doing it. Shit, you do it too. If you don't do it, then quit telling everybody what I'm doing. You know, case in point, banks get nervous when you set up trust. Why? Because not only do you know something, it could be inadvertently something that they can tether in that you might want to avoid taxes. I was listening to a lawyer today. I ain't going to put his business out there, but I listened to this lawyer for about an hour today in arbitration. And after this hour, he made such a bold statement that I couldn't contain myself. Now, again, I'm mediating. He articulated the fact that the reason why they have federal deposit insurance is to protect the consumer. And then he goes on to explain how FDIC should be used by the institutions to bring do-gooders to justice. Now, after I listened to his presentation, I simply asked that, okay, let me get this right. So is it legal under United States GAAP to deposit funds that are FDIC insured into an account that you've had for over 90 days and not be able to produce the last 90 days CTRs pertaining to the account? Now, of course, Mr. Bay now is the bad guy. The lawyer's calling me everything but a child of God. And case in point, commercially, accounting is based upon who you are in that transaction. Beneficiaries are the equivalent of drivers that can go, even though they know how to drive, they might operate that vehicle without insurance, at least for a couple of days, a week, a month, until they get back on their feet. That doesn't mean they don't know how to drive. They're just out there uninsured. Now, commerce is such a cumbersome highway, you can't turn left, right, or sideways without bumping into somebody else commercially. That's why you're required to be bonded and insured, because if I'm going to come in your driveway, I'm probably going to run over a rose bush or something. I'm going to damage something because it's so crowded on this highway. So here's my insurance, pay for another set of roses, and we can keep everything moving. This is why you ask for this information. In accounting, I'm required to ask for CTRs, but public officials are afraid to give that type of information. And it's really an oxymoron, like military intelligence and jumbo shrimp.
They think you're going to take it and go straight to the IRS with it.
Yeah.
They think anyone asking for CTR is the IRS whistleblower. That's why I said there's so much misinformation earlier.
Right.
So then if we're doing, so if the court, not to interrupt you, Kassim, but so if the court is a bank, then the bank, they don't have a routing number. Well, they don't have a routing number in the public because they have
the bank has a routing number and have access to routing numbers. And let's be real clear, when the judge is on the bench making his notes and attestations and jurats, and because some judges are notaries as well, be clear that they are petitioning everything in that activity first as commercial activity, commercial transactions. Now, in Bank of America, they call it what? CTRs. In Fulton County Superior Court, they got a different acronym. That's asymmetric information, but the function is still the same. The fundamental proponent is still the same. It's going to hedge into a ledger where they have to, it's like it's put in suspended animation. Something happens commercially, there's a value, it's placed in the fund. Now, until you guys settle, argue, have another court date, they get to use those funds. Now, when you finally go to court and settle, they've made money off those funds. And there was no reporting of it being lodged, hedged, monetized, and this, that, and the other, because the individual, the judge, whoever it was, they only was required to what? Do a report, say it went in, and then again, their retirement plan.
Information about
Go ahead.
that.
Go ahead.
So, we were engaging that way, and then I actually went to California because it was the easiest jurisdiction, like you said, in America. Anywhere you want, if there's anything you want to do, there's a license to do it. So, I flew out to California as I was doing those the work for that year, and we registered as a bail bonds company. Registered a bail bonds company, right?
Right.
And it wasn't until we went to the certification course that's required that I received, to be honest with you, all this time we spent in law, and the professor just literally broke it down to us that it's insurance and reinsurance.
That's all it is.
So the reason why there's no money is because there's no money to collect. So how it works is you go to jail.
Right.
You post bail, right?
Right.
The bail company steps in. What I do is that I ain't giving the court no money.
Right.
I'm telling the court I'll be the guarantor.
The guarantor. Right.
What happens is, what you don't know is, I have what's called I have to open a fund as a bail bonds, and what we traditionally do is put it in a CD, and that CD is locked.
Right.
And then so each time someone bails, by law we have to put 30% of each fee to that fund, and that fund stays in the bank. And that is the collateral that guarantees, so that there's no money going in between anyone's hands. So there's no CTRs that need to be filled out.
Right. By their standards, and like the ability to insure transactions and an ability to reinsure a transaction is 90% of the transaction. The other 10% is documentation. The whole aspect of commerce has been deduced to a substandard. When you look at anything other than me reaching in my pocket, handing my gold to you, and then you're handing it to the next person, if we're not doing that, then you're in this artificial system of conveyance where there's rules for different statuses of individuals within that money supply classification. Now, if we're going to stack up what's the safest type of transaction and the least safest, M3 conveyances here in the United States is the safest. 99% of individuals who are in a federal or state sentence, for whatever reason, probably was not handling M3 conveyances. But I guarantee
they converted it to war script.
Right. I guarantee you that whatever your drug charge was, your domestic charge was, whatever it was that turned criminal and you're doing time for, it was in that most narrow conveyance, which is an M1. M1 transactions literally tell you, this is why GAAP does not consider cash as a GAAP item, because it has that adverse balance proponent. Cash can easily in one jurisdiction be great, and it can also be a liability in another person's hand. It just depends on what the blue lights and the man in the hat want to call it. You got $300 or $500 on your person, you got a check stub. If he don't like you, it's drug paraphernalia. Just like if you work for government, this is a good, we're having a great time. We're getting ready to raise money for this, that, and the other. This was basically, all consent. Everybody's great. If I find out you're whistleblowing, it's a bribe. It's all about statuses. So as notaries, I want you to practice fundamental precepts of M3 conveyances. If that person shows you a 90-day CTR, then you are free to hand what you have to them to convey. If they cannot produce the last 90-day CTR for the account that's in question, you have a default, which is the court. And when you place your value within that court system, you determine what goes in and how it comes out. And if you want it to be the most safest,
But that was my question. If court is our default, then how do we obtain a right number for the court if we're issuing an asset to the court?
Say that one more time.
If we're issuing our conveyance or whatever transaction we're doing, and we're doing it through the clerk of court or the court,
right?
Then how are we able to issue a CTR, and if the court is the financial institution, but they are not providing their routing number?
The CTA, they are providing. Let's stop right there in the aspect of, it's not that they have. Let's be clear. If you were charged with child support or you got to pay a fee, they're going to tell you who to make the money out order to. If you're writing a check to the court, they're going to tell you who to make the check out to. If in some jurisdictions, if you're going to swipe a credit card, they're going to give you all of the routing information. There are accounts that they give you, but we can't confuse the way the courts take in liability funds versus how they take in asset funds. If you're talking about liability funds, they got merchant server accounts, credit card machines, all the stuff that conventional people do, which means you're dealing in that tandem. If you're talking about M3 conveyances from an asset proponent, you're taking, these are documentary drafts. This is why you don't need routing numbers and account numbers affiliated with the ABA system, because that's their system for those type of transactions. The tracking system, if you don't see one, that doesn't mean you don't have to articulate one. You can create one. An author of a bill of exchange can author the method of how it's routed and how it's to be conveyed. I'm only talking about bills of exchanges and K1s because this required the least amount of preparation. And it's the easiest thing that anyone can do. If you can do a UCC, you can put a bill of exchange into the CRIS and you can remove it with a K1. The most difficult part of the transaction is the filling out of the verbiage, which is going back into the reason why I'm telling you to start using these AI tools and learning your own set of verbiage. I only talked about that one citation because there's a whole bunch of citations you can use, but that gets you into what accounting method are you using? Are these asset funds or liability funds? Who's going to be the recipient of it? The clerk who's got a checkbook, she's just a custodian. So anything that she tenders out, whether it funds the person's account or fund terrorism, she's not going to be liable because she doesn't own the fund. She's just a custodian of it. It's the person who authored that documentary draft and instructions who's going to be held liable if it ends up damaging another person. But again, if it's a public official, they got a public hazard bond. Claims can be made, arbitration clauses can be implemented, and arbitration can commence. The public tribunal, by default, is there to help the beneficiary receive value that otherwise could be conveyed outside of this 31 United States Code statute that I just put up here. Now you can construe it and manipulate and change it to fit your specific transaction, but the parameters are: if you went to court and that court gave you an award, well, they're going to determine how that award comes out. That means all the bar members get paid first, and whatever's left, the IRS is going to be looking at you. If you do it privately, nobody, as far as the alphabet boys, get anything unless you want them to. Case in point, lawyers who practice litigation retire by being brought into arbitration panels and sit on private cases because they're being brought in for their expertise. They're being brought in for what they know as far as asymmetric information, and this is how they're willing and dealing. Anyone who doesn't make that round table privately ends up in public court. The clerk, by default, is there for the public. So again, if we're all tied in trust, it's a real simple transaction because anything you're doing for public policy is for the public. How you shorten your process and your leash is make the recipient who's going to receive the instrument a beneficiary in the trust. There isn't anyone that's going to say, oh, you can't do this and that and the other when you're operating in a trust agreement. When you're not in trust, this is when you got to conform to their rules.
So we can use our non-banking banks for these CTRs.
You can say that again. You can use your what?
Our non-banking banks.
Yes, you can use that. Remember, the citation that I'm giving you is what they can tell you without giving you legal advice. Everything else that you got to be licensed and bonded to do, stay the fuck away from when you're doing these processes. If you got to be licensed and bonded to do it, you're not private. They're going to give you a code, a citation that's the middle of the road. Usually what tilts you in one way or the other is the institution, who you are in the transaction. The key is, does the if the recipient has to receive money as an M2 and M1, let them take the burden. That's why this stuff has to be insured and reinsured. And then it makes the transaction easy. It makes it easy from that point. Not trying to be difficult. I just don't want to get into a solicitation proponent because a couple of these will tie in to the SEC, and that's not where I want to take
I have a question.
Sure.
Really more like a scenario that I want to walk through, if you don't mind.
Go ahead.
And it has more to do with the CTR reports and like the different forms of quote unquote currency on the form, right? Okay, so I'm gonna just give an example. Okay, so if I am let's just say I have a speeding ticket, right? And instead of paying the speeding ticket, I decided to subrogate the case.
Okay.
And in the subrogation of the case, I asked for a writ of discovery to discover the charging instruments in the case.
Okay.
Do I do a CTR report and file that with? Okay, so let me go back, because when I subrogate the case, the goal is to pull those bonds and receive the funds from the bonds, right? But I don't know what they pulled out of the exemption account until I get the writ of discovery, right?
I see where you're going with that, and that is a way of doing it. Now I'm going to kind of just lean on what you're saying from, in my opinion, a little more practical way.
Okay.
Like, by default, if you classify all I can give you, like let's go here. You're a fiduciary who's expected to be a fiduciary for the next 20 years. So in order for me to preserve that, my commercial activity has to stay within M3 conveyances to eliminate the possibility and chance of tripping into a jurisdiction that may cause me to have to relinquish my fiduciary duty. So because I'm in this type of contract, I have to approach all conveyances from the safest position.
Okay.
So you orchestrate your transaction on its face as an M3 conveyance that has the ability, because M3s also have M2s and M1s built in. It's just not your job to make it a 2-in-1. That's what everybody else's job. So that way, as long as the way your transaction should look is whatever you're going to do, there should be a transmittal letter on top. That's instructions. Then financing statements. Those are your UCCs. You want to do UCC 1s, you want to do UCC 3s, and you want to do 5s. Now, after you do that 5, now you can author a letter of credit from what you put there. And then if it needs to be converted from an M3 to an M2 or an M1, that's when you create, author verbiage that constitutes a money transmitter bond, which means they can transmit the M3 to a 2 and a 1 from their asset account, from their liability account. You just have to set it up where they have the ability to do that. So every transaction, in order for it to be insured up front and reinsured on the back end, is that you're going to do the transmittal letter, UCCs, letter of credit, and the money transmitter bond verbiage. That constitutes insurance and reinsurance. This is all you are required to do in that type of transaction.
So if I'm subrogating, that's really a different jurisdiction, basically.
That's a whole different kind of You're teetering into right.
So what? I can hear that.
That's a whole different way you skinning the cat. The subrogation is one way. What he just described is another way.
Okay.
He's not saying your subrogation part isn't correct. He's just carrying you in a different way to keep you armed and feeling for your fiduciary duty, where you can get the best out, in my opinion. But it's all on what you're trying to get out of the transaction.
Right, because my goal and I guess that's where I'm kind of like, okay, I guess the question really is, if I'm subrogating a case, do I really need CTR reports? Because CTR reports are really for commercial activities where subrogation is more or less common law.
Well, let's put it in the perspective of accounting.
Okay.
Yeah.
If I'm going to do accounting,
Mhm.
I would do the safest transactions M3 conveyance. If I'm going to do conventions, then I will rely on common law. And there's a difference between accounting concepts and conventions. See, as a Moore, I am collecting tributary taxes, so I don't have to deal with CTRs and all of that. You have to understand the difference between accounting concepts and accounting conventions.
Conventions. Okay.
So conventions deal with tradition and culture.
Mhm.
Concepts are connotative. Keyword con is asymmetric information, baby. That's all it is. A group of people have come up with a rule that what they gonna call money today. Today, if it's purple, it's money. Tomorrow, if it's yellow, it's money. The board gets determined. They get determined that.
So when you say asymmetric information, what you're saying is it's more subjective based on how you use it because it's like double speak. So it could be
just like in our industry, you guys as notaries, you deal with so much asymmetric information. You don't really you're not really understanding the power of what you have by having that title. The oldest legal guild were scribes and notaries. So everything that now has its own department used to be done by notaries. If you were sent to jail, if you went to prison, if you was having land bestowed, it was all done by notaries. And then as we developed to today, it was compartmentalized. So when you are experiencing commerce, even though you're a public notary, you really are a deputy secretary of state. You're looking to see whether you're determining whether lawful, legal, and again, only a notary can determine what's lawful, legal, binding in commerce.
Which is interesting because I figured something out
Mm-hmm.
so I was doing some stuff for my mother for her estate.
Mm-hmm.
And in that, I filled out an application for her, but I used our family seal, right?
Right.
And I found out when I turned the application in, so we signed or we autographed, I'm going to say, the application, but we didn't leave an open signature. We assigned the signature or the autograph, okay? And put the seal on it. And I noticed that they couldn't do anything with it. So they gave us the original application back. And I couldn't understand it because normally they normally keep the application. But when I went back and read a little bit more about seals and stamps, for one, I didn't know a seal is a stamp. Had no idea.
Correct.
Okay. So when I was reading that, I figured out that if you put your seal on it, you own it. They cannot trade that.
Exactly.
That was scary to me. But yes, I get what you're saying now. So as far as the notary, it's kind of like notaries have a lot of pull, but as a fiduciary, if you have your seals in place, you're kind of on a level of a notary. You just have to know how to use that seal.
How to use it exactly. Remember, commerce is in these spaces. So we're really dealing with three different spaces, and the one that the people pay the least attention to carries the most value and weight. So listen to me real carefully. There's this race to get you into this digital space. This is why with notary training now, I'm telling you, just like bringing your books to class, bring the AI with you. The reason why I want you as a notary to treat that AI as an 8-year-old. Because it's an 8-year-old. Now, you got to be careful what you tell an 8-year-old. If you tell an 8-year-old that you want to kill Superman, he's going to tell you how to kill Superman. He doesn't know whether you really mean it or not. He just knows that that's what you ask. That's what he does. Now, the more you use him, he starts to learn how you assimilate information. This is a language model. It's not designed to make no notary and a compliance officer obsolete. It's simply a tool to help you gather chunks of information very quickly, put together outlines and contracts, and take complex ideas and be able to put them in sync quickly. It's simply a tool, just like a hammer can hang up a painting much better than a shoe. So think about what you was handed was a hammer when you had a shoe. This most of your commercial transactions deal in a device and metadata or device that deals with metadata that is the most unsecure device on the planet. More people do banking with cell phones than they do with laptop, desktops, and going to the bank. They trust the cell phone. But the cell phone is not the technology to trust when it comes to this type of value that we're talking about. So let's back up to what's the most valuable information. The information that's in your notary journal that is 90 days old, that hasn't been contested, is a security waiting to happen. And as they push you digitally down this yellow brick road, notaries who figure this out now, what do you think the new security is going to come from? Your journal. You need to develop your own language model. You need to take everything that they immediately make digital, put it right back in print. Because when you bind that book, when you make that book, only you can testify to the authenticity of its content. Now lawyers are buying these litigation/arbitration cases because the practices that they're doing in arbitration, they can't technically practice that in litigation because the business model is different. They make money off of having people argue when there ain't no money. That's the hook. They can't go before a notary who's going to determine what money is and what isn't. They need two incompetent fiduciaries arguing over something that don't exist. That's why immediately before someone is actually adjudicated, they automatically charge you. They can't make unbonded statements. Understand this very clearly. Any public official who is saying words out of his or her mouth, those words have to be what? Bonded and insured. Do they say stuff? Of course they do. Do they lie? Of course they do. Lying is not illegal. Perjury is. They can do and say whatever they want, but remember, just because you can do whatever and say you want, there's consequences from it. And commercially, you have to start the dialogue with, okay, before I respond, can I see your public hazard bond? And if they don't give it to you, that's your green light to implement your UCC and go in that proponent. You're reporting their failure to give that to you as tax fraud or insurance fraud, really. It's just like we're in a vehicle and you hit me. And you know you're supposed to have full coverage on this vehicle when you hit me from the rear. Now, if I ask you for license and registration and you don't produce it, police show up, somebody's going to be cited. It's the same principle here. Commercially, the public system, and this is a tough pill for most to swallow, but as notaries, just wear it with a badge of honor. The commercial system is not designed to respect citizens. They only respect private citizens. If you are a citizen of government, they don't respect you. You're just a good little sheeple. They're going to create rules and govern you because that's what they've been doing. There is nothing in it for them to respect who you believe, what you believe, how you do. It's their job to keep you busy on the plantation. But when they run into a private individual, one, we don't know exactly who this person is. Now we got to tread carefully. How is it in their world? Anything you say, they'll tell you up front. Anything you say can and will be used against you. That should be foggy to anybody. So the documentation, the conveyances, if they have a position to use against you for monetary gain, they have not done anything wrong by doing so. You're trying to play the game the right way. Like, look, I'm simply here to move my chess piece the way it's supposed to be moved. I'm here to give you enough commercial energy to do what you came to do. But I'm not competing with you. I have my own system, my own valuation system. And again, if you have gold and silver and tangibles, you can do that. You have resources, you can do that. It's just in the accounting convention versus concept. Accounting concepts are going to continue to what? Change and evolve. They're going to change and evolve.
I need to find my glass. Let me go there and get punched all in the eye.
Most of the information that we deal with as notaries are tethered to what position are you playing when you witness versus attesting. You do know the difference between witnessing and attesting, right?
Yes.
Okay. That's real powerful. Everyone in the public doesn't want you.
I think it would be a good idea, Dr. Bay, to explain that, though.
Okay, let's expound on that.
Yeah.
It would be to everybody's best interest to realize the public would rather for notaries to simply witness their fraud than attest to it. Conform that and reword it how you want to see from that. The public has a vested interest that you witness the fraud minus attesting to the fraud. As long as you witness the fraud, they'll take the argument that the opposite party consented, so therefore no injury was done. But buddy, if you attest to it, who has to be bonded and insured if that person was actually damaged? Attesting is like you're doing a court proceeding and you are reading the document that you're putting your seal on. You're authenticating and validating the contents that's there. When you're witnessing and jurating, only thing you witnessing is that they signed it before me. And here comes the kicker, because we're at that part of the conversation. Because I had to actually do one today with this lawyer that I'm talking about, where I had to refuse to attest and jurate. There's nothing wrong with having a refusal in your record. Might work in your favor to refuse when you know that lawful legal money. I'm on the scary line, but y'all got me here, so I'm gonna say it. If you witness lawful legal money not being conveyed, and it's required that you give sworn testimony, now your affirmation could include what you actually witnessed. Let's say, for example, when you go take a document to UPS and you get it notarized at UPS, do you actually see that notary record that transaction in a notary journal when you get something notarized at UPS?
No.
Okay. Now watch this. Because you are a practitioner and you know that every notary document that you see, there's supposed to be some what? Noting and minuting by that notary who provided that stamp and seal. Like what you learned about the seal, Empress? The seal is a what?
Stamp.
The stamp. Okay. And okay, are you supposed to be putting your stamps on documents that have not been recorded in your notary journal?
No, you're not.
Okay, so if you know that UPS offers a service where they stamp documents and don't place it in the journal, can't every document that ever was notarized by that agency be challenged and overturned?
It can
especially if it damaged you, especially if somebody did a divorce or they did whatever and they went there and did that. Wasn't you damaged by that?
Yeah.
Now, I'm not giving legal advice, but I told everybody who's a civil law notary that business is good. These rates, these recent bank failures have increased our volume by 300%, and I'm telling you why. Because 99% of a lot of the stuff that everybody's sitting all willy-nilly with, you guys that have at least been listening to stuff for 6 months, it's a lot of correcting to be done. Process serving is simply your ability to get up in the morning, package your documents, and take them to the post office. Because once you take it to the post office, it's considered delivered at that point.
Mm-hmm.
You can spend the next 10 years providing a service to correct records, especially if it deals with commerce, trust, and the likes of. With this new AI, they're going to start clamping down on your ability to become a notary. It's already happening. Notaries can administer oaths, so as long as you have already studied under those 690 hours of apprenticeship, you can bring someone who's gone through that same tutelage and administer an oath and deputize them, and they'll become a notary.
I wanted to ask a question about that.
Sure.
Do we need to update our credentials annually?
Yes, you do.
I hadn't gone to the arbitration site to look.
Yes, this is why I want you to go back. I'm literally just giving you the cheat sheet. If you ain't looked at your arbitration video since you became a notary, go back this month and do it. Right, because I can document that so you're on top of your continuing ed.
Okay. Thank you.
The key, keep in mind, individuals that are in the wrong status that want to go, because I hear a lot of stuff about status correction and this, that, and the other. Notaries can administer oaths. So if somebody come to you with a driver's license, but they want to utilize their Moorish nationality, couldn't you attest to that? Couldn't you administer an oath?
Absolutely.
All right. There's a lot of ways. There's a lot of ways to definitely to approach that. There's a lot of ways to approach that. So I really want you guys to really see the level of implementation from that. Do we got any other questions of anything we covered up until this point?
I have one more quick question about the CTRs. So let's say, remember we were going through, I can't remember whose process this was, or something you were showing us about making sure our bills, if you will, are in good standing, right?
Right.
And it was some kind of way that we were tendering payment or turning the bill itself into a bill of exchange.
Yep.
Would you, so in that, they've been accepting that, so that's fine. But in that ledgering it, I've been making sure I ledger those accounts, right? So on the back side of it, I claim the equity, and I noted and benefits that in the ledger. But with that, do you do a CTR report with that company?
Every transaction that can be construed as a gap transaction, there's a CTR or a series of CTRs in a commercial ledger to substantiate that transaction. So if I ever need to show those records, I can from a different perspective. But the only thing I usually show is a PF 990.
Now what's a PF 990?
Well, basically, it's kind of your not get out of jail free, but it's your IRS ledger that you can substitute. If you don't have an audited financial, as a fiduciary, you can give them a peek at the PF 990. Matter of fact, everyone who's doing arbitration now in their case syllabus, we already start the PF 990 ledgering for the client. So they just pick that math up and keep the ledgering going from that standpoint. But that becomes a record that you can publicly display without going into your private proponent.
Gotcha.
It's a ledger.
I got a quick question about what you just said about deputizing someone. So if I'm a notary and I wanted to deputize someone, I can make them into, I can deputize them as notary?
Exactly. It's about having the case study. Like the original guild is the same as it is today. When you become a notary, effectively, whether you got to pay a fee or take a course, you got to go before a notary to become a notary. That is the fundamental. Just go before those that are already notaries and demonstrate that you're competent. You brought it up, so I'll give you one.
Would they be able to get their own notary seal?
Just like corporations can get their own corporate seal, you can get a notary seal if you're operating. Let me say this the right way to not get you in trouble and not violate any laws. If you're going to be practicing notarial law, you just need a notary in good standing with the state to say that you're in good standings with that territory and state. That's technically all what you need. Now, there are public notary services that you probably want to be a state notary to really go out and do, but there's a whole lot of other stuff privately that you can do, and you just need to be able to be under the good graces of a good standing notary in that territory and jurisdiction. So it really depends upon where you finna go with notarial law. For example, for those of my Moorish brothers and sisters who have had instances in the past that they feel is going to eliminate them becoming a notary, all you need to do is draw up an affidavit. It doesn't have to be 100 points, 30 points, 50 points. Adequate points that demonstrate that you're competent to practice notarial law. I'll give you the cheat sheet. You got ChatGPT. Ask ChatGPT to draw you up a notarial affidavit. Have it created, critique it, modify it to your liking, take it before a notary, and don't look back. But again, this is not legal advice. This is just me rattling off the top of my head.
He said, let the church say amen.
You said have the Chat GPT help you create a notarial what? Affidavit?
Right.
Okay.
There are language models that are not available for Windows and Mac users. So when you use ChatGPT and you're on Windows and Mac, the preferred browser, Firefox, you can enroll into the free account. It works better if you get the paid account, but if you are on limited means, you can use the free account and exercise those add-ons and plugins. You'll get the same effect without the scrutiny. I want to get into some tactical trust training later on this evening for anyone who wants to go down that rabbit hole to talk about very specific prompts for engineering proper trust documents and M3 conveyances. If we have anyone who's willing to participate, then I will send a link and we'll dive deep into that. But I would want you to have it so you'll get the effect, because I'm gonna tie you into my data set from that standpoint. That course will probably run maybe 30 minutes to an hour because it's mainly gonna be prompts. I'm listening for suggestions, and we kind of want to brainstorm prompt engineering from that perspective. That's going to be the hardest yet easiest part of what's being done. The language model does the ability to convey, print, and give framework in seconds, but it has to be told like an 8-year-old what you want it to do, which requires a certain level of information. A lot of you guys have information about your case, but I think some of you haven't quite really expounded on the capability. I literally use ChatGPT to teach these courses now. This class itself is being recorded and being transcribed by ChatGPT. And once I get done, it'll give me 30 different versions of what we're talking about. saying the same thing, but 30 different versions that can be resold, yes, sold, and repackaged. And this is just audio. If you combine case law, specific outcomes that you're looking, you can assign your chat GPT to take a role. Like if you're trying to get loans approved, have the chat GPT be the underwriter. Have it give you questions specific to a transaction so you know how to fill out the application properly. You can actually have it scrape the lender's website and start asking it questions to see if the loan qualifies for funding. The possibilities are limitless.
But that's in a paid version. That's in a paid version, correct?
I would recommend paid versions because you can combine these apps, and they have just released Code Interpreter. Code Interpreter will write you a Python script. It'll write your code. It's a matter of just what's most advantageous. I have a tendency to speak a whole lot faster than I can type, so I love the fact that that's like I'm having a conversation with you. I can speak to the AI, like Siri and all that good stuff. Alexa. It makes my job a whole lot easier. You can ask it to give you a 10-minute lecture or a 5-minute lecture, or something like I'll teach a course that runs 3 hours. You can run it through the AI and it'll take it and put it in 3 minutes. Straight to the point with bullet points. Or if you need to expound, it'll expound on it. It's a language model. Remember, people are word-controlled people, and commerce is definitely controlled by the parameters of words that are being used. You have a model that can disseminate words in seconds. There's just fundamentals that you just have to incorporate into your data set. Any other questions before we switch gears?
What time are you doing the other class?
I'm gonna need at least break to grab some dinner, so I'll say I'll be back by 8 o'clock, 9 o'clock, for about 30 minutes.
Okay, I have to cook dinner, so I'll keep my eye out for the invites.
All righty, that'll
and I
work.
can be on. I can listen, but I'll have to be on like my headset and just kind of stay silent.
Right. As long as you're able to see the link, you'll be able to see the prompts, how they're being put out there, and we can definitely do that.
Okay. I can do that.
All righty, that'll work.
All right. Unity and love, great class. I appreciate it.
Peace and love, peace and love. Any other questions? Any other questions before we jump out and switch gears?
Question.
Sure.
We're gonna get together. I will tell you just one thing, give you a heads up. I'm going to need Fedora redone on my computer. I lost everything I've done in New Cache. The good thing is I still have my New Cache ledger that I had sent to you, which was the latest one I had done.
Good.
So I just downloaded it, but we need to put Fedora back on my machine in order to get
the updated ledger. I got you. Okay. We can definitely do that. That'll work.
Okay.
I'll set up a team viewer to do that.
Okay, that's perfect.
All right. Well, look, great class. I enjoyed everybody's level of participation. Look, don't forget, you can definitely get more of this content on WTDTAradio.caster. Those of you that are going to be up for the additional training in Syntactical Trust with the AI, the prompt will go out and within the hour with the time and the link we're going to use to do that. With that, I'm going to say peace and love, family. Peace and love.
Dr. Bay?
Yes, ma'am.
You're going to we going to schedule for tonight, or are we going to wait until tomorrow so you can finish the class tonight?
What I'll do, I'll finish the class tonight, and I'll get the syllabus to you. You'll have the syllabus tonight, so we can go over it tomorrow.
Okay. All right, perfect. Thank you.
Alrighty.
Peace and love.
Peace and love.